Hearing in the appeal, Spiller and Mother against Joseph and others.
Yes, Mr. Price.
May it please your lordships, in this appeal I appear for the appellant and William Bennett appears for the respondent. Andrew Caldecott, Queen's Counsel, and Sarah Palin appear for the interveners. Facts of this case are reasonably straightforward and they are set out in the statement of facts and issues, and I will take them as read. There are, as is apparent from the facts and issues document, a number of factual disputes between the parties. I submit they're not relevant to the determination of this appeal, and insofar as I am wrong on that, the court must proceed on the basis that any factual dispute will be resolved in favour of my client. This application that now comes before the court was made by the respondents shortly before this case was due to be tried by a jury. My client's sole concern has been to rebut the attack on his pleaded case and ensure that it is all determined by a jury. This is his entitlement, except to the extent that the defence is perverse or bad in law. The attack on the defence has taken a variety of forms, including a diversion into the construction of the Conduct of Employment Agencies and Employment Business Regulations 2003, of which both parties were unaware at the relevant times. As for the issues now before the court, they were not even argued before Mr. Justice Eadie at first instance, with the somewhat surreal and possibly unfair consequence to the judge that we may be debating the effect of his judgment in Lowe and associated newspapers without having the benefit of his application of that judgment to the facts of the present case. A significant issue in this appeal is whether the facts on which my client wishes to rely were referred to in the words complained of. This issue was not even raised in the Court of Appeal, even though it formed a central part of the judgment, and no oral argument has ever been directed to it until now. However, one thing is clear following the Court of Appeal's decision. In my submission, this is material to the appeal before your lordships. The justification defence is now no longer under attack. It follows, therefore, that this appeal must proceed on the footing that a jury could conclude as a fact that the first respondent demonstrated a contemptuous, cavalier and unprofessional attitude to contractual obligations, and that the respondents may not necessarily adhere to the terms of booking agreements signed by the first respondent. The purpose of this appeal is to reinstate the comment defence, which in theory should be an easier defence to establish than justification, because putting it in layman's terms, it does not require the jury to agree with the defendant. My client is not a media organisation, he's not even a journalist, he has no wider interest in the law of defamation. He finds himself here because of the strange way in which the respondent's application has proceeded through the lower courts, and because the Court of Appeal judgment happens to raise points of law of general public importance. It's my intention to address these points of law very much within the context of the facts of the present case. And my submission will be that irrespective of whether the defence of fair comment is liberalised, my client clearly has a properly arguable defence. There is, as your lordships will be aware, current debate as to where the balance should be struck between freedom of expression and the protection of reputation. But it is surely in everyone's interest that the law should be clear and cases should be approached on the basis of principle, whatever those principles should be. This has not, regrettably, been the experience of practitioners in relation to fair comment or indeed defamation more generally, and it's been a recurring theme as regards fair comment. There's references to it in the Porter Committee, in the Fawkes Committee, numerous judicial statements about how unsatisfactory the law is. This case may, on one view, be considered to be a storm in a teacup, but it's also a paradigm of what is wrong with our law and procedure. This court does have the opportunity on this appeal to clarify the defence and, if appropriate, to liberalise it. The notice of appeal sets out 3 points of law of general public importance. The grounds can be found in the core bundle, tab 1, page 7, just to remind the court what they are. They're set out in paragraph 6.
Sorry, what are we, paragraph 6 of what?
It's core bundle, page 7. It should be the first tab of core bundle saying form 1 on it.
But I mean, don't we look at the statement of facts and issues?
Yes, one could look at it there. The statement of facts and issues, I think,
I
does
think
say...
that's where we generally
Yes, well,
look.
I'll
Pages 16 and 17, paragraph 20.
Yes, my lord. Yes.
They may be the same. I mean, I don't think we
Yes, it's probably easy to deal with them there. Yes, they are the same.
Yeah.
Just to remind the court what they are. The first one is whether paragraph 19 of Paul and Sheng is an accurate statement of English law. In particular, whether it is a requirement of the defence of fair comment that a publishee should be in a position to judge for himself how far a comment is well founded, and whether any obligation to explicitly or implicitly indicate, at least in general terms, what are the facts on which the comment is being made, is a qualification on or an additional hurdle to Section 6 of the 1952 Defamation Act, which merely requires the facts to be alleged or referred to in the words complained of. The quotation is from the judgment of Lord Nichols in Cheng, the requirement to explicitly or implicitly indicate, at least in general terms, what are the facts on which the comment is being made. Second issue, which is related, is this, at 22, the extent to which it is necessary for a defendant to particularise the supporting facts in the words complained of in order to take advantage of Section 6. And the third issue, whether a material or fundamental inaccuracy in the facts stated in the words complained of is fatal to the defence of fair comment, where there are other facts stated or referred to in the words complained of which can be proved and on which an honest person could hold the relevant opinion. These issues all relate to the interaction between the comment and the supporting facts. However, I submit that they must be approached, if they're to be approached on a principal basis, within the context of the other elements of the defence. One of the reasons that I say this is that I do submit there's a significant element of conflation in the respondent's submission, particularly on the question of whether my client has been honest. In my submission, this is irrelevant to the issues raised by this appeal and is, in any event, a matter for the jury. Each element of the defence of fair comment is there, at least in theory, to fulfil a particular role in holding the proper balance between protection of reputation and freedom of expression. And it's important that they are not conflated. English law seeks to hold the proper balance by the application of principle. It also attributes different roles to judge and jury in relation to the application of these principles. Questions of fact are to be determined by the jury at trial. The function of the judge at this stage, before trial, is simply to preempt perversity. In my submission, the first and most significant principle is that the defence only applies to comments. It does not apply to defamatory statements of fact. If a publication contains defamatory comments and defamatory statements of fact, the defence of fair comment cannot protect the statements of fact. In my submission, this is surely a very significant factor in determining the relevance of a misstated fact to a comment defence. The claimant already has a potential remedy in relation to the misstated defamatory fact, irrespective of whether he has a remedy in relation to the comment. In the present case, the respondents contended at first instance and in the Court of Appeal that the relevant words, in other words, those words that are the subject of the comment defence, were incapable of being comment. That contention is no longer pursued, so we have to proceed today on the basis that the jury will find the relevant words are comment. And it's...
do we work on the basis that paragraph 10.1 of your defence is the comment, do we?
Yes. I was going to take the court to the words complained of it, just to go through, and if we were in front of a jury, how I would be structuring my argument. But it just simply points out which bits are fact and which bits are comment. But yes, I have set out those words that...
Page 23 of the Appendix Part 2? I mean, I just want to make sure I know what the...
Yes. Yeah. Those passages identified at paragraph 10.1 of the amended defence on page 23 are the words that we submit our comment.
Are we now working, you say, on the basis that that is recognised to be comment, and the question is,
yes,
have you got enough material, so to speak, behind them to support that as an arguable defence?
Yes, because it's an adversarial process. We've had the argument in front of Mr. Justice Eadie. We've had the argument in the Court of Appeal about whether these words are capable of being comment. The Court of Appeal has found that they are comment, in fact, but certainly that they're capable of being comment. We're at the interim stage, so it's a case to be determined by a jury. There's been no challenge to the finding in the Court of Appeal that the words are comment or capable of being comment. Therefore, for the purpose today, we have to assume that those words are comment. And the issue before the court relates to the supporting facts. The facts that are to sustain that comment, or those comments. And there's obviously two issues. One, what facts can be relied on, and the other is the relevance of inaccuracy.
But I mean, the thrust of the comment is, here's a group who you may book them, but beware, they may not turn up. I mean, that's what it comes to.
Well, may not turn up, yes. I mean, that may be putting a bit high. I mean,
well, I'm sorry, I'm just reading paragraph 10.1. In essence, I paraphrase, they may sign a contract for your booking, but will not necessarily adhere to it.
Yes.
I understand that to mean, watch it, they may not turn up.
Well, that's a possible meaning, yes. Obviously, it's a possible... I mean, I'm just making the point that it may not necessarily be that meaning, but let's assume for the moment that that is the meaning, that they will not show, that they may not show up. Yes. Yeah. Let's take that as... I mean, I'll take that as the meaning for the present purposes. Yes, that's... that they may not turn up. It's a prediction as to the future. And we had the argument in the Court of Appeal, and there were authorities referred to, and it was judged to be capable of... In fact, the Lord Justice Peel held that they were comments. I
don't see how a statement as to the future can be anything but comment.
Well, yes. Right. So... Even let us assume the meaning is they may not show up, that's still a comment.
I mean, I just want to know what the thrust of it is. That's the comment, and now what we have to look at is whether, so to speak, you've got enough material that you're allowed to look at to support that as an arguable defence.
Yes. Yeah.
Yes. I just want to see where we are. That's all. I'm not.
Yes, well,
I find the case extremely difficult. I have no views on it at all.
All right. Well, I'm sorry if I didn't make that clear. Would it be possible to go to the words themselves, just so I can...
Yeah, they're all very helpfully set out in the Stone Facts and Issues, aren't they?
Yes. We can go to them there. Paragraph 7 on page 3 of the Statement of Facts and Issues, page 13 of the bundle. 1311 Events is no longer able to accept bookings for this artist as the Gillettes, care of Craig Joseph, are not professional enough to feature in our portfolio. Are not professional enough to feature in our portfolio, comment. And have not been able to abide by the terms of their contract, we say fact. Continuing with the words of the posting, we say the show's an enjoyable soul on Motown experience, which is popular for many events throughout the UK. However, following a breach of contract, we say that's a factual allegation. Craig Joseph, who runs the Gillettes and Saturday Night of the Movies, had advised 1311 Events that the terms and conditions of contracts hold no water in legal terms 270307. We say that's a factual allegation. And then the remainder is all comment. for this reason, it may follow that the artist's obligation for your booking may also not be met. In essence, Craig Joseph, who performs with arranges bookings for the Gillettes and Saturday Night of the Movies, may sign a contract for your booking, but will not necessarily adhere to it. We would recommend that you take legal advice before booking this artist to avoid any possible difficulties. Instead, we recommend any of the following: professional bands and artists. So we have the factual basis as an inability to abide by the terms of their contract, a specific allegation of breach of contract, and a reference to a communication from Craig Joseph on the 27th of March 2007.
So, sorry, the facts are, in the top bit, not being able to abide by the terms of their contract,
Yes,
and then following a breach of contract,
yes,
that's fact 2, is it?
yes.
And then fact 3 is what?
Movies has advised that.
Yes.
In the
Yeah, the
communication.
reference to the email, that a communication was sent.
It's the fact that this has been the advice that's been given
Yes, that
by
was,
the movies.
those are the,
Contracts hold no water in legal terms.
yes.
I mean, there is a slight problem with that not being entirely accurate, is it?
It's not entirely accurate, clearly. I mean, but I was going to deal. I can deal with it right now if the court would prefer. But my point is, it's arguably not material when one looks at the thrust of the email, and that a jury may not attach quite the same significance as a lawyer might to an element of misquotation. I mean, sorry.
But those are the 3 facts.
Yes, those are the 3 facts.
The last is from Craig Joseph down to 27307, is that right?
Yes.
That's the last of the fact.
That is the last of the facts, yes. And the following comments are all based on those facts.
But sorry, again, I'm just trying to get the overall shape. One issue is, although there's no reference to the earlier business with what's it called, Landmark Bournemouth, whether you're entitled to rely on
Yes.
that as a fact.
Well, I would submit that there is a reference to that.
Oh.
In have not been able to abide by the terms of their contract. And, of course, we're
I
talking here of a question of fact for the jury. Would a jury be perverse to conclude that a reference have not been able to abide by the terms of their contract could include more than one breach of contract?
So query whether that encompasses the March 06.
I think it was December.
Well, December
05.
booking, March
Yes.
failure.
Yes. Indeed. I mean, that was certainly a factor that was in my client's mind, as apparent from his witness statement, when you see the reference to your offer of work for my shows over the years was minimal and neither helped nor hindered our diary. In other words, you're not very important to us, we can mess you around. And that's what he felt happened in relation to the Landmark booking. I mean, carefully went through with the first respondent, are you free on that day? Yes, I am. Are you absolutely sure? Important client. For me, yes. Sends out the booking form, comes back signed, hotel's happy, arrangements are made. All right, albeit a short time afterwards, he does turn around and say, I've double booked, it was a mistake. But we don't accept that in the circumstances. We say that something better came along, and that's an issue of fact for the jury. But it's certainly...
Sorry, why does it matter if they're double booked? Why isn't it still a breach of contract?
It is still a breach of contract, yes. I mean, it's clearly a breach of contract, but it would probably be... It's worse if it's a deliberate breach of contract because something better came along. It shows something more about this gentleman's attitude towards contractual obligations. In other words, if it suits him, we say, obviously it's an interim stage now and he's not here to be cross-examined on it, but our case is that if it suits him, this man will play fast and loose with contractual obligations. And you can see that from his conduct from the very outset of their relationship, right to even the Coombs wedding booking, a small thing, small example, but here is a man, we say, who sends an email wanting £270 extra in cash, so there's no confusion with his paperwork, to play an extra half an hour, makes clear that he doesn't want my clients to know about anything about it, even though the booking's with them. Then when we get hold of this email, and there's nothing in his records, he turns around and said, oh, well, we never actually played the extra half an hour, and that's why there's nothing in my books about this cash payment, which we say is untrue. And that he did get the money. He did try and avoid paying my client. And I mean, these are just one of a number of examples on which we wish to rely in order to sustain the comment. I mean, on that occasion, there's an issue because the Coombs wedding took place after the first publication of the words complained of. But as far as the landmark is concerned, which is the first booking, which my Lord Brown raised, the point is that we say this is covered by the words have not been able to abide by their terms of their contract. And it would be really rather ridiculous in a case of serial wrongdoing that you could only rely on one particular breach of contract.
I mean, how many times did it go wrong? The landmark one we just talked about, the first.
Yes.
Then the one that prompted the
yes.
when they took a booking within the year, etc., etc.
Yes.
And then the Coombs wedding. Those three.
And the email. I mean, the email is...
And the email itself.
Yeah, the word.
No, I mean, I'm just...
Yes,
absolutely.
I'm sorry, yes. It's those...
Do we know how many successful bookings there were with your clients?
May I just take... I think it was 6 bookings in total.
6 worked, so to speak, without any problems.
Yes, 6 bookings in total and 2 which went wrong. Well, 3 if you take the Coombs one.
So, I see. So 6 includes the 3 we've discussed?
Yes.
Thank you.
And I think it's in my client's witness statement, but this is not the sort of conduct that he normally experiences. And that's one of the reasons that prompted him to make the posting.
I mean, do I understand sort of acts of this sort are booked through all sorts of different people?
Yes. Yes, I mean...
it's not an exclusive agency or anything.
No, that's really sort of part of the point. I mean, the Gillettes have got lots of sources of work, and 1311 didn't help or hinder their diary. I mean, one could see a similar situation. You book for a wedding. No one's saying you wouldn't turn up necessarily on the day, but maybe a month beforehand there's a fantastic concert that comes along, and they might want to try and wriggle their way out of it if they possibly can, and say, well, we can get another band for you, whatever it may be. I mean, it's really what these various allegations that are set out in the particulars of fact, what they say about the respondents, or what, in terms of fair comment, what an honest but perhaps unreasonable person could think they said about the respondents. Somebody who perhaps has a particular view on adherence to contracts. I mean, there's nothing... Why is this contract different from any other contract, one asks, when one looks at that email? And what is the particular feature of this contract that renders it holding no water in legal terms and being a formality? I mean, one searches in vain in the words complained of. It rather comes across, I mean, I would put it in these colloquial terms, that he comes across as a wide boy. Not only is he flagrantly breaching contract, and we know from the Part 18 response that he took a deliberate decision not to inform 1311 of this booking. He admits that in the Part 18 response. He was well aware of the re-engagement clause, and he didn't want to tell 1311. He says it was because there was a run-in with the venue, of which my client knows nothing. There's no witness statement from the venue, and in any event, that's an issue for trial. But a professional artist who was in this circumstance, having signed a contract, would turn around and say, look, we've got this booking, I'll sort it out, and I'll pay you the commission.
All of this sounds very much like justification.
Yes.
And this is the area at the moment that I have the most difficulty with. If you make a general comment, these are the kind of people you can't rely upon to turn up, which implicitly is saying, because of their past track record, it seems to me a matter of what's reasonable. You ought to have to justify the inferred facts that you've alleged, whereas I think you're going much further and saying, even if there was one occasion on which they'd failed to turn up and a reasonable person wouldn't deduce from that they're unreliable,
Yeah.
If an unreasonable person might deduce from that they're unreliable, that's quite enough
Yes.
to establish the defence of fair comment.
But then otherwise we get into a situation which I submit is contrary to principle, where different types of comments have different types of requirement factually. I mean, the universal test now in terms of comment is the honest person test, as I've described it, which is could an honest but prejudiced, obstinate, unreasonable, irrational person hold the comment on the basis of those facts? And
Well, this brings us down to, it seems to me, one of the issues that arises as to whether there really is a one-size-fits-all approach to fair comment, or whether you're not dealing with a different situation if you're making giving a review of a play you've just seen from this kind of situation where you're making a comment which has implicit in it facts which will not be known.
well, then,
To the
I
general
mean, then the
public.
law becomes incredibly complicated.
Well, it may be that the law has become incredibly complicated.
Yes, but one has to. We can't have a system of perfect justice where every single, where the law applies perfectly in every situation. There has to be an element of hard principle will give rise to certain situations where there's perhaps not a perfectly just result. But that principle is necessary so that there is certainty in the law and so that there's overall fairness. And also in terms of freedom of expression, the reason why we need to have simplicity and we need to have a user-friendly defence is that so that the
Sorry, you need to have what?
a user-friendly defence.
I'm sorry, a user-friendly defence.
We need a
Yes, I
user
see.
to encourage the expression of opinion, which is taken to be something, a good thing, and for ideas to be tested out in the marketplace. And there must be a distinction between fact and opinion.
Yes.
Opinion must be subject to a less rigorous burden in terms of factual proof. That must be right. And in any event, as far as this appeal is concerned, we have Section 6 of the Defamation Act. So Parliament has already provided and that Section 6, Parliament has provided for the appropriate factual basis for a comment when the words contain statements of fact and statements of opinion.
We'll get on to Section 6, but I mean, is there a possibility that Section 5 and Section 6 go very closely together? That Section 5 is dealing with statements of fact which are defamatory,
Yes.
and saying, well, the fact that one of them is untrue doesn't matter if it doesn't alter the overall effect
Yes.
of the publication. Then, but what about what about fair comment or unfair comment in those circumstances? Oh, well, it won't harm your defence of fair comment either.
Yes.
Looking at the same factual scenario.
Yes. But unlike Section 5, Section 6 can affect, you can affect the meaning of the defamatory allegation complained of in a material way. Because in Section 6, there's no comparison between the facts that you've got wrong and the facts that you've got right. So you could get facts wrong that leads a person who's reading the comment to view it as a more credible comment, a more reasonable comment. But all you need to do to succeed in the comment defence is to have enough facts that an unreasonable person could hold the opinion. So you could, in Section 6 terms, get someone reading a comment coming away with a possibly mistaken impression because there's a misstated fact.
That's right, isn't it? I mean, say you as a commentator have a reputation as being a very measured, responsible, sensible sort of person, and you get one of the underlying facts hopelessly wrong, so that if you had known of it, you wouldn't have dreamt of making that comment. The fact that somebody who is thoroughly unreasonable might supplies your defence?
Yes.
Even though your readers know that you're a reasonable chap who wouldn't say this except for good reason.
Yes, well,
Right.
I mean, that is what Section 6 provides. Why should, I mean, putting it the other way around, why should the claimant be vindicated in relation to a comment that has a sufficient factual basis. Why? I mean, the proper test of opinion about whether it's lawful should be if it has a sufficient factual basis, not that it has to be correct or true or the jury have to agree. I mean, we're going back to the 19th century. And it's all very well to come up with an extreme case of someone who's very reliable, who makes a material misstatement of fact in his publication, but there are some other facts which somebody unreasonable could rely on to hold the opinion. One can do that, but in the real world it doesn't work like that when expression of opinion is being put out in a variety of forms by a variety of people. My learned friend puts forward a test, I think, of whether the facts materially affect the opinion detrimentally as far as the claimant is concerned. So if the fact has a bearing on the reasonableness of the opinion, if you can put it that way, that's his test. But if that was applied strictly, it would be far more restricted than Section 6, and one can imagine all manner of comments being found to be unlawful, because people don't always get their facts right. And I mean, I do submit that one has to hold fast to these principles. The first principle is, are the words fact or comment? If they're comment, then the comment regime applies. We do not treat different comments differently. And in my submission, there's no principled basis to do that. I mean, the other point, on the facts of this case, that we have a justification defence that's viable. So, for that reason alone, it cannot be said that there is no chance of persuading a jury that we've got sufficient of our facts right, that we've got substantial truth behind our comment. Because we have our justification defence. It's very different from London Artists and Littler. I mean, is this a material misquotation? We would say arguably not. And I was going to deal with that later, but I can come on to a number of reasons why it's arguably not a material misquotation. I mean, and material in the sense of balancing the element of falsity against the element of truth when one looks at the email as a whole. But I say we don't even have to go there, because the right test for opinion is whether an honest person could hold the opinion on the basis of the facts. An honest and unreasonable person. That is the only logical test to which opinion should be subjected. If the facts are defamatory, and to take the example of my Lord Brown, of the commentator who's relied on to get his facts right, if those facts are that fact is defamatory, there'll be a cause of action in relation to the defamatory fact, subject to privilege. So there will be vindication in relation to that. And if it's not defamatory, I'm afraid it's tough, because there is no remedy here, without more, at least, for the publication of false statements of fact, even in the media. There's a recent case of Thornton and Telegraph Media Group Limited, Mr. Justice Tugendhat, where he says that there is a bar to be set before something is regarded to be defamatory. It is a hurdle, and that hurdle means that there will be allegations which are untrue, which may cause damage, but there'll be no remedy in defamation. There might be a remedy in malicious falsehood.
In what, sorry?
Malicious falsehood.
Malicious falsehood.
Yes, but if to take the example, if there is a major fact that's the basis of a defamatory comment, chances are it's probably defamatory. If it's not defamatory, it's just tough, as with any other non-defamatory fact that has not been published maliciously. And that's the point I make about we don't have a system that provides a perfect remedy for every falsehood that appears either in the media or anywhere else. And underpinning that is considerations of freedom of expression and considerations of substantiality and considerations of encouraging speech. Because any civil action in relation to speech is an infringement of Article 10, whether or not it succeeds. And if it succeeds, it's an even greater infringement of Article 10 and therefore has to be justified as being necessary. So there is no warrant in the authorities or under Section 6 for treating a comment which is an inference of fact any differently from any other inference. And moreover, if the facts upon which the inference is based turn out to be untrue, it doesn't mean that the inference is no longer a comment. There seemed to be some suggestion to that effect in the respondent's argument. I mean,
Sorry, is an inference of fact by definition a comment?
well, it can be, yes. I mean, an inference, if it's recognisable as an inference, it's likely to be a comment.
But you're using the expressions interchangeably, are you?
Well, no, because there may be pure comments which aren't inferences of fact. I mean, someone's horrendously ugly, or to take one of the cases, there may be pure value judgments, pure evaluative statements, or there may be inferences of fact where there are one or more facts and then a conclusion is drawn from those facts, and it's well recognised that in those circumstances the inference is likely to be treated as a comment and therefore subject to the less rigorous burden in terms of the supporting facts. And by less rigorous, the defendant doesn't have to persuade the jury that the inference of fact is true or correct, merely that an honest person could express or hold that belief on the basis of facts that can be proved. So a comment which is an inference of fact, no different from any other comment. I submit that these comments are not pure inferences of fact anyway. I mean, it does say for this reason, but the other...
Sorry, you have to speak up a little bit.
Sorry,
I just didn't hear what you're...
I submit that the comments on which my client seeks to rely, they're not just inferences of fact.
And then you added something.
Because they involve evaluative statements in themselves. There are predictions of what will happen in the future. I mean, the words do have "for this reason," which identifies the comment as an inference from the preceding facts. But even if one didn't have that, it would be perfectly arguable that those predictions as to what may or may not happen would be comments in any event, because they're predictions as to the future, and therefore inherently uncertain and inherently subjective. So I'm dealing still with the first stage of the distinction between fact and comment, even though this is not directly an issue, because I need to deal with it to submit that the defence needs to proceed on a principled basis. So there's no discrimination between different types of comments. And in the past there has been a discrimination between comments which impute a dishonourable motive and those that don't. It's the only time I think there's been a suggestion that there should be different types of factual regimes to different types of comment. That is no longer the position, and I think the Faults Committee, certainly there's been debate about it, but in terms of the case law, it's clear that there is no special regime for comments which impute a dishonourable motive to the claimant. It's the same test for all comments. And whether the facts turn out to be untrue or not is irrelevant to whether the words are fact or comment. The words are fact or comment just by looking at the publication complained of, and it can't make any difference as to that first stage if the facts are untrue. If the facts are untrue, the defence may fail at the second stage, but at the first stage, where you're looking at whether words are fact or comment, it simply depends on the wording of the publication complained of without any concern as to truth or falsity. So we are stuck with the finding of the Court of Appeal. We're not stuck with it. The respondent is stuck with the finding of the Court of Appeal. These words are comment.
Except for the three facts you've identified.
Yes, but my sole concern is to get that amended defence back in front of a jury, and I rely on those words that are set out in paragraph 10.1, to which Your Lordship referred me. Those are the comments that I want to be able to contend to a jury that you don't have to agree with those comments, members of the jury. You don't have to think that they're reasonable comments. You just have to ask yourself whether there is a sufficient foundation that an honest person could form that view. And that's an easier test for me to have to surmount than the test I'd have to surmount if it was just justification, which I do try to surmount in any event in relation to justification, and there's no problem with me seeking to justify a comment, permissible to do that, but it's a much more difficult test when one gets in front of the tribunal of fact, because you have to show that your comment is right rather than merely one that an honest person could hold.
You said a moment ago whether the words are fact or comment depends on the words used
Yes.
in the relevant context.
Yes.
I mean, if the words are used of an individual who has suddenly come into the limelight because of a particular episode, then the person reading them would understand that you're making a comment about that episode. Whereas if there were no episode, then you might form a quite different conclusion as to whether the words were fact or comment.
I would respectfully accept that if something is before the public already,
Yes.
it may be that that's a relevant factor in terms of construction of the words. But it doesn't mean that just because something is not before the public already, it can't be a comment.
No.
The opposite is not true. And certainly there are suggestions in some of the decisions of Mr. Justice Eadie that's very material in whether or not to construe words as fact or comment. And those are decisions where, in fact, Mr. Justice Eadie has held that it would be perverse to find that the words are anything other than comment. And we were faced with the opposite situation here, where it was being argued that it would be perverse to find they were comment. And that argument has been dealt with and put to bed, and I don't have to worry about it here because this is an adversarial process, I submit, and I've got the finding that these words are comment.
Does that finding apply equally before the jury, or is it up for grabs again as to whether they're...
Oh.
I mean, assuming you get your defence in,
Yes.
how does it play then before the jury?
Well, I think my learned friend might be a little bit unhappy with me if, having made submissions to the Court of Appeal that this is a perversity test, and the Court of Appeal has accepted that and reinstating that aspect of my comment defence. It might be rather difficult for me to say that the Court of Appeal have ruled that it would be perverse for them to be anything other than comment. But the wording of the judgment does rather suggest that the words are comment. That's at tab 2 of Appendix 1.
Yeah. Paragraph?
Sorry.
Paragraph 30.
I'm most correct. Yes, paragraph 30. There's a finding there that the words are comment.
But sorry, but I mean, you would prefer them to be comment.
Yeah, very much so. I mean,
No, but I mean, but is it open to the other side, to trial, to say, I suggest members of the jury, you regard them not as comment but as fact? I mean, is it open to them to say that?
I haven't really turned my mind to...
Well, it may not matter, right?
You did begin by saying we had to proceed on the basis that it was comment or capable of being comment.
Yes. Well, today, for the purposes of my argument, we have to proceed on the basis that the jury will find those words to be comment.
Either the jury will find them to be comment, or the jury's got to be told they are comment.
Yes.
One way or the other.
But I mean, I wasn't
Yes.
submitting that my learned friend couldn't go to trial, which is obviously a completely different situation, and argue that they're not comment. But I mean, we're at the interim stage now.
While we're on the judgment of the Court of Appeal in the appendix, which begins at page 71, is that right?
Yes, my lord.
Wait, could you go to page 73? We're now, I think, under paragraph 4 of the judgment of Lord Justice Pill. But it does seem to me there's a lacuna between 73 and 74.
Oh, there is. There's a page missing.
Oh.
It would be very helpful to have that page.
Now, the page missing is after page
Page 73.
5.
Yes, after page 5.
After page 5, yes, I meant to ask this before. Paragraph 4 finishes with a colon at the end of paragraph 9 of the judge's judgment. And then, if you turn to page 74 of our volume, it's perfectly obvious that there's a page missing. We have no paragraph 5 at all, nor do we have an end to the judge's paragraph 9.
Yes, I'm very sorry about that, and I will remedy that hopefully over the short term. But what I think that Lord Justice Pill is doing is citing from the judgment of Mr. Justice Eadie. So, if your lordships want to...
I know, but it still is going to be incomplete because we won't have a Court of Appeal judgment para 5.
Now, Very sorry about that. If the court would like to look at it now, I think we can go to Mr. Justice Eadie's judgment, or I can provide you with the missing pages.
Let's just have the missing page, unless we need to focus on it at this moment.
Sure we can get it. Sure we can get it.
Yes, I mean, I've got one copy here. I think it's just citing from the emails between the parties, but I'll make sure that.
Yes, we'd each like a copy, please.
So, first issue is it fact, is it comment?
Yes.
Second issue is this. The second principle, I submit, is that the comment must have a sufficient factual basis. And it's only at this point that the tribunal of fact considers truth or falsity. So, at the second principle, you go outside the wording of the comment or the publication complained of, and you look at the evidence behind it. And one has to bear in mind the issue is not the truth or falsity of the comment, it's the truth or falsity of the supporting facts. It's this principle that's in issue in this appeal, and it's this principle which has proved to be the most complex and problematic, because it gives rise to a number of...
You can only talk about truth or falsity of the facts once somebody's put them into a pleading. I mean, how do you identify a false fact or true fact? Somebody has got to make allegations of fact to which you then apply a test of,
Yes.
is this true or false?
Yes.
And so it's the pleading that does that.
It is the pleading that does that, but it's by reference to the publications complained of. So I identified the three factual allegations in the publication complained of, and I fleshed them out in the defence. And similarly, my learned friend in his reply, or at least in his particulars of claim, has positively pleaded a false fact as depriving me from reliance on the defence of fair comment. So these issues obviously are defined by the statements of case and emerge from the statements of case. But the point I'm simply making is that the relevance of truth or falsity goes to the supporting facts, not the comment. So what are the subordinate questions that arise from this principle of the comment must have a sufficient factual basis? Well, first of all, do the facts have to be referred to in the words complained of? And secondly, what is the relevance...
do the words have to... How do you put it?
Do the words have to be referred to in the words... do the facts have to be referred to in the words complained of?
Do the facts have to be referred to in the words complained of?
And what is the relevance of inaccuracy? I describe this as a second principle. The comment must have a sufficient factual basis. But in the cases, for example, in Chain, Lord Nichols breaks this down into a number of different principles. But in my submission, it's really one overriding principle, that the comment must have a sufficient factual basis. But that breaks down into whether those facts...
Well, Lord Nichols says the comment must be seen to have a sufficient factual basis. And for myself, that seems to be almost the major issue that we're here to look at, whether he's right or wrong to postulate that.
Yes.
This all interlinks with the section 6 point.
Yes.
Which refers in terms, I forget now what to, it refers to the facts alleged or referred to in the words.
Yes, but as a matter of logic, if you're going to have an honest person test, if you're going to subject comment to whether an honest person could hold the comment, even if that honest person's unreasonable, then as a matter of logic, the only factual hurdle should be to establish sufficient facts for that test to be passed. It doesn't make any sense to submit those facts to anything more rigorous, because if those facts are stated in the words complained of and they are defamatory, there'll be a remedy in relation to the facts in any event. In terms of the comment, as a matter of logic, the only sensible factual test is that you've got enough right to satisfy an honest person.
I mean, everybody accepts now, do they, that we're not talking about fair comment at all. It might be terribly unfair.
Yeah.
We're talking about honest comment.
Yes.
That's a received truth in the whole field, is it?
Yes. Everybody.
I mean, it is rather misleading to call it fair comment.
Yes. Well, your lordships have the opportunity to rename the defence.
I know.
I mean,
Parliament in 1952 still thought it a good idea to call it fair comment.
Yes. Well, maybe we've moved on a little bit from that. I mean, we can't go for another 60 years with judges complaining about how appalling the law is and how incomprehensible it is to a jury. And we are now looking at things through the taxonomy of the Human Rights Act. And in my submission, it's not appropriate, well, it is desirable that the name of a tort should reflect, so far as possible, its elements. And one would think for a jury, it's possibly not difficult, but I mean, if you believe an opinion's unreasonable, it may be quite difficult to see that somebody else could hold that opinion. They have to put themselves in the position of a different person to them, possibly. Somebody who's capable of being obstinate, stubborn, prejudiced, jumping to conclusions on scant factual material.
We're going beyond simply a nice simple test of, is the individual who made this statement, did he make it honestly?
Yeah.
Because he may have been entirely honest and he may entirely reasonably have believed in the truth of the substratum that led him to make the comment. But if that was not accurate, then he's liable.
Yes. I mean, there's an argument that once it's comment, honest belief of the commentator should be sufficient. But I'm not.
No, you're not.
I don't think even I'm arguing for
not
that.
even you are going that far.
No, and I'm going further
Yes.
than Mr. Rusbridger, editor of
Yes.
The Guardian, in
Yes.
my submissions on liberalising the law at the moment. But I'm not going that far. I do submit that malice or lack of honest belief should be discarded altogether, because it opens up a wholly unnecessary line of inquiry into the defendant's mental state. I submit that it is sensible to retain an objective test. But it's once the words are comment, the level of proof for a defendant is relatively low. And that's consistent with the Strasbourg jurisprudence as well, where a value judgment must have some factual basis. Value judgment without any factual basis may be excessive, which is the word used by the Strasbourg courts.
I don't think it arises here, but I mean, don't the interveners sort of talk about privileged material also?
Yes.
So that could be inaccurate, is it?
Wholly inaccurate,
Yes.
privileged material, yes.
Yes. So there's that,
Yes.
that qualification or addition to what we're talking about.
Yes. I mean, there's a whole number of reasons why somebody can make a comment that the publishee thinks seems really sensible on the face of it, but turns out to be quite unreasonable. But nevertheless, that comment remains lawful. So, if one has a distinction between fact and comment, the only logical test to submit the comment to is the honest person test. And if that's right, the only factual obligation on the defendant is to prove the existence of sufficient facts in order for such a person to hold the opinion. The third principle is that the subject matter of the comment must be a matter of public interest. This is not directly raised by this appeal, although it was before the Court of Appeal. I submit that this is an unnecessary requirement. I don't know how far your lordships would like to hear submissions on that, but I was going to leave that to the end. I put some wider submissions in my written case, but as I said at the outset, my primary concern is for my client to reinstate his comment defence. The fourth and final principle is that the claimant can defeat the comment defence by proving malice, which in this context, certainly as so far as where the commentator is the defendant, means the defendant did not hold the opinion that he expressed. And I submit that this is also unnecessary. But whether it's necessary or unnecessary, what is clear is that this is the only subjective element in the defence. There's nothing subjective about whether the words are fact or comment or whether they have a sufficient factual basis. So one must ask, how do these principles apply to this appeal? Well, it is now unchallenged that there is a real prospect of the jury concluding that the relevant words are comment. The facts on which the defendant seeks to rely to support the comment are set out in paragraphs 9.3 to 9.15 of the amended defence. There is no suggestion that they are incapable of proof, so we have to assume the jury will find them to be proved. There has never been any suggestion that a jury would be perverse to conclude that an honest person could express the comments on the basis of these facts. That question has never been asked, never been posed by the respondent. In the various challenges to the fair comment defence, that challenge in relation to the honest person test has never been made. The Court of Appeal has accepted that the subject matter of the comment is one of public interest.
You say that's an optional extra, but there it
Yes.
is. We're not we don't have to go down that
No.
road.
Same applies to malice. I mean, notwithstanding some of the respondents' submissions for this appeal, there is no application for a ruling that malice must succeed, and we are unaware of any case in which the issue of malice has been determined against a defendant on a summary basis. In other words, you can't make a credibility finding against a defendant without him being cross-examined, generally. In any event, that's not being suggested here, but we see references in the written submissions of the respondent to my client having lied. This is wholly irrelevant for the purposes of this appeal and is in any event a matter for the jury. So the only potential obstacle in my client's way to having a viable comment defence is, firstly, is he entitled to rely on the facts in paragraphs 9.3 to 9.15 of the defence? And secondly, is the misquotation of the email fatal to the defence?
So you say that those are the critical two issues. Are you allowed to rely on 9.1 to 9.15?
Yes.
And two, is your misstatement fatal?
Yes.
Because it was on those two bases that you lost.
Yes. And that must...
And you lost on the first basis because of this December 05, 9.13, 9.14, which was said not to be available to you. Is that it?
Well, that's encompassed in whether I'm entitled to rely on 9.3 to 9.15.
I know, but did they say you weren't allowed to rely on any of the others?
It wasn't entirely clear. I mean, part of the problem was there was no argument at all about this at the hearing. But it seems to... I think what Lord Justice Pill held was that those particulars alone could not support the comment because there was too much of a gap between that particular breach of contract and the publication of the words complained of, and the reference to following a breach of contract was clearly a reference to the Bibis breach. I think he probably did find that there wasn't a reference to that contract, but my point would have been, if I had the opportunity to make submissions on it, and I think it probably was within my skeleton argument, but my point was unable to abide by the terms of their contract is a reference potentially to more than one breach.
I think it's clear that Lord Justice Pill downed you on both, because if you look at paragraph 42, he says there is no reference to that in the words complained of. That is to say, but that is referring to the re-engagement clause and the Bibis contract. The contract is not identified in the publication, so that's why you fail on Bibis. And then on landmark, he deals with that at 43 to 46. And the main point there seems to be, I mean, I think that maybe there's no reference again, or no identification of that contract, but and he prays in aid the gap in time.
Yes.
So I think you lost on both.
Yes, he does appear to contemplate the possibility of the landmark breach coming within Section 6, which he doesn't even contemplate in relation to the Bibis breach. That's a difference, I think, in his analysis of the two breaches. I mean, his analysis of the Bibis breach ends...
Analysis of what?
His analysis of the Bibis breach ends on his finding that it wasn't referred to. or the particular breach wasn't referred to. That was the end of his analysis. In relation to the landmark, he identifies a submission at the end of paragraph 43 that it was submitted that alleged breach was sufficiently identified in the words complained of. And at 44 he says, as Lord Nichols stated in Cheng, paragraph 19, the comment must explicitly or implicitly indicate, at least in general terms, what are the facts on which the comment is made. Does Section 6 of the 1952 Act permit the defendants in this context to rely on the breach alleged in paragraphs 913 and 914? I have come to the conclusion that the defence of fair comment should not be permitted to stand on an application of Section 6 on the strength of an alleged breach of contract with a hirer in December 2005. The dispute arose in March 2007, following an alleged breach by the claimants of the re-engagement term in their contract with the second defendant. That breach gave rise to the publication which led to the present action. The breach of contract relying for present purposes of a contract with a hirer in 2005, as between the claimants and the defendants, there were no repercussions in that contractual relations proceeded without complaint until March 2007. The words following a breach of contract in the words complained of cannot be taken as referring to the December 2005 breach. So just pausing there. He does make a finding that there wasn't a reference to those particular words, and pausing there, we would have submitted that it was a reference to the earlier words. And then he adds, in my judgment, the jury could not probably base a finding of fair comment against the claimants given the nature of the comment upon a breach of contract in 2005, 14 months before the breach, which led to the publication. On this ground, the judge's decision to strike out the defence of fair comment is to be upheld. It rather looks like in those two sentences, he's saying, well, even if it was referred to in the words complained of, the honest person test isn't satisfied, essentially. I have, with respect, detailed criticisms of the Court of Appeal's approach and analysis, which I was going to come to after I dealt with the legal propositions for which I can contend.
And what about this misstatement, the misquotation? How do they deal with that?
Fairly briefly, starting at paragraph 38 on page 14.
In the untruth, yeah.
In summary, what Lord Justice Pill does is he discounts reliance on those particular words because they were misquoted, but doesn't actually deal with the relevance of an email as a whole. He just focuses on those words because those are the words that were set out in the publication complained of. Whereas my submission would have been, you've got to look at the email as a whole. And that's what I seek to do in paragraph, I think, 912. What was unsatisfactory about all this was that we approached the Court of Appeal hearing on the basis that there was an issue as to the regulations. It's a contractual point, we don't have to worry about that. But in terms of fair comment, simply on the basis of whether the words were capable of being comment and whether subject matter was capable of being a subject matter of public interest. Then my learned friend raised an issue on the respondent's notice, relying on what he described as, I think, a fundamental error in terms of the misquotation. But the respondent's notice never dealt with the question of reference and whether I was entitled to rely on the particulars that I set out in 9.1 to 9.15. What should have happened on this analysis, part of my particulars of fact should simply have been struck out. I approached the appeal on the basis I had viable supporting facts on which I could rely, and nobody was saying that I couldn't. The argument was simply that the misquotation was fatal to the defence of fair comment. So, hence the absence of analysis in relation to this issue.
You can identify this issue in extreme terms by imagining that the publication had said, last Saturday, once again, Gillette's failed to honour their obligation to turn up. It's then shown that actually they had turned up last Saturday. You would say, nevertheless, because I said once again, I can rely upon the inference that there were a whole lot of other history that justifies my comment. even though the only specific matter that I mentioned has been shown to be false.
Yes, and that would be right. in my submission.
That's your submission.
Yes, I mean, it's not this case because we did say following a breach of contract. So we identified a clear and deliberate breach of contract.
Yes, but it goes to the point as to whether you can rely upon landmark, upon things that you did not specifically refer to in
once again,
yes.
must be a reference to something else, and it would be wholly illogical. And
well, Lord Nichols would say you can't because it was in no way identified, so it falls foul of his proposition that the facts must be identified for the reader. Isn't that right? I mean, that's one of the critical issues, at least, that we've got to address the facts that arise here.
He says the comment must explicitly or implicitly indicate, at least in general terms, what are the facts on which the comment is being made.
Yes.
We just left it at that. It's arguable that with the once again, there is a reference, an indication of further breaches of contract. The problem arises with the next sentence, which is the reader or hearer should be in a position to judge for himself how far the comment was well founded, and that may not be possible if you don't identify the breaches. But those two sentences do not. One doesn't follow from the other necessarily. No. You could have an indication, an implicit indication of some facts, and the reader would not be in a position to judge for himself how well founded the comment was.
Yes. Yes.
And looking at it from the other way round, I mean, let's take that example. Yes. They didn't show up on that particular Saturday. Although they did show up, but they did show up,
yes.
And that was wholly wrong. But once again, and let's suppose maybe 3 times before that, they've not shown up.
Yes.
Are they to be vindicated in relation to a comment that says they're unreliable, in terms of their adherence to contracts, and that they may not show up? That would be absurd. One shouldn't look at this in terms of punishing the defendant for getting something wrong. One should look at it in terms of entitlement to vindication. One should look at it in terms of Article 10 and what's the effect of having zero tolerance to factual inaccuracy? What's the effect of not allowing defendants to rely on material that could sustain a comment? Let's to look at it in wider terms. But there was never any challenge in the Court of Appeal to my reliance on those particulars of fact in 9.3 to 9.15, which went into a very detailed analysis of that email. I mean, the materiality of turning it into contracts is said to be that what you're doing here is you're turning a criticism of a specific contract into something more general about an attitude to contractual obligations. But I come back to the basic point, which is, why is this contract different from any other contract? What's identified in that email as a logical criticism of this particular contract? It doesn't come across that way at all. A jury could conclude that that email suggests something general about these respondents. And that is why my justification defence has been allowed to stand intact. And Mr. Justice Eadie allowed my justification defence to stand intact even when he found against me on the regulation. So he found against me on the regulation, so I couldn't allege a breach of contract, but he still allowed me to justify meaning that they had conducted themselves in a way which demonstrated a contemptuous and cavalier approach to contractual obligations. Some learned friend comes along and says, well, you've turned it into something general, and people are going to think that my clients have a generally bad attitude to contracts, or they're going to think it's a contract relating to a client and a band as opposed to an agent and a band, and that makes a big difference. But at the end of the day, the jury could conclude, looking at that email and looking at the totality of the respondent's conduct on which we rely, that these people have a contemptuous attitude to contracts, generally. You can't trust them, because if it suits their purposes, they'll try and get out of a contract. We're entitled to argue that as a fact. But as far as fair comment is concerned, all I need to persuade the jury is that somebody could think that. So if one imagines a conversation going on where 2 people are discussing this email and the breach of contract, one says, well, hang on, this posting by 1311 is way over the top. This was just a re-engagement clause between an agent and a band, and the contract that was criticised was just that particular contract. And the other person can say, well, I tell you, in my experience of life, if you've got somebody who behaves in that way, who's prepared to do that, it doesn't really matter. Once you've broken one contract, you're quite capable of doing it another time when it suits you. Now, I would submit that that's not an unreasonable approach. to the matter. But even if it was unreasonable, even if it was a rush to judgment, even if it was somebody who was prejudiced, then the comment remains fair, that's the right expression, or at least the honest person test is satisfied. If the other party to the conversation, the one who takes a very strict view about contractual obligations, could hold that opinion about the respondents. So it's not arguably a material misquotation. The existence of the justification defence is a complete answer to any suggestion that a jury would be perverse to regard that misquotation as non-substantial, as non-material. Otherwise I won't be allowed my justification defence. The starting point in any analysis about the two issues identified, namely, am I entitled to rely on the facts in 9.3 to 9.15 and what's the relevance of misquotation, is section 6 of the 1952 Act. I've set it out in my written case.
Could we have the reference in the authorities so that we can see its context?
Yes. In the authorities, it is to be found at tab 39, which I believe is in bundle 2, right at the beginning of bundle 2.
Yeah.
One has to look at section 6 in conjunction with section 5.
Yes.
Starting with section 6, in an action for libel or slander, in respect of words consisting partly of allegations of fact and partly of expression of opinion, the defence of fair comment shall not fail by reason only that the truth of every allegation of fact is not proved, if the expression of opinion is fair comment having regard to such of the facts alleged or referred to in the words complained of as are proved. The words, if the expression of opinion is fair comment, must be equivalent to the honest person test. Looking at section 5, in an action for libel or slander in respect of words containing two or more distinct charges against the plaintiff, a defence of justification shall not fail by reason only that the truth of every charge is not proved, if the words not proved to be true do not materially injure the plaintiff's reputation having regard to the truth of the remaining charges. The crucial difference between these two sections is that section 5 involves a comparison between what has been proved and what has not been proved, whereas section 6 solely focuses on what has been proved. At common law, where a defendant set out the factual basis for the comment in the words complained of, any inaccuracy was thought to be fatal to the comment. It's within this context that section 6 came into being. It's quite clear that the purpose of section 6 is to widen the range of factual material that can be relied on to support a comment and to permit considerable tolerance for inaccuracy in the supporting facts by focusing on what could be proved, not what could not be proved. If it's necessary, and I submit it's not necessary, one could resort to section 3 of the Human Rights Act 1998 to ensure that it's construed generously in a matter that is consistent with freedom of expression. If I can break down...
Were section 5 and section 6 both introduced into the law of defamation at the same time and in 1952?
My Lord, yes. One can break down section 6, into three elements. The first element is what facts are alleged or referred to in the words complained of. I know that's right at the end of the section, but in my submission that is the first question that one needs to ask. And I've described these facts as the factual pool. It's the pool of facts which a defendant can go to sustain his comment. The next question is, what facts from the factual pool have been proved? Objectively proved. And that...
Did you say objectively proved?
Well, just simply proved. I'm just emphasising it's not a question of whether the defendant believed those facts to be true. He's actually got to go and prove them. So that is a hurdle. And one can consider alternative ways of putting this defence together, where once the words were comment, the defendant simply had to believe the words were true, but that's not good enough. He's got to actually prove some sufficient factual basis, and I've described those as the proved facts, namely those facts from the factual pool which have been proved. And the final question is, could an honest person hold the opinion on the basis of the proved facts, which, as I've described, as the honest person test? So you look at what was referred to, you look at what can be proved, and at that point you ask the question. And clearly these are all questions of fact for the tribunal of fact, in this case a jury. So at the interim stage, which is where we are now, the court can only intervene where a jury would be perverse to reach a particular conclusion. And this is a high threshold. It also involves assuming, for this purpose, that the facts on which the defendant relies will be proved unless the claimant establishes they are demonstrably false. The consequence of this is that where Section 6 applies, the only relevance of a false allegation of fact in the words complained of as regards comment is that it requires the defendant to resort to at least one other provable fact from the factual pool on which an honest person could base the comment. That is the sole relevance of factual inaccuracy.
So you say any individual factual inaccuracy is, so to speak, immaterial, although if it's a defamatory allegation, it will be separately actionable unless you can prove it.
Yes.
Yeah.
And it is interesting to have a look at Kemsley and Foote in terms of the old common law approach. Shortly before Section 6 was enacted, and that can be found in the Authorities Bundle, Volume 1. At tab 19. And the particular passage...
Hang on a second. Yes.
The particular passage is in the speech of Lord Porter at page 357, right at the bottom. Just at the end of the penultimate sentence, in a case where the facts are fully set out in the alleged libel, each fact must be justified, and if the defendant fails to justify one, even if it be comparatively unimportant, he fails in his defence. Does the same principle apply where the facts alleged are found not in the alleged libel but in particulars delivered in the course of the action? In my opinion, it does not. Where the facts are set out in the alleged libel, those to whom it is published can read them and may regard them as facts derogatory to the plaintiff, but whereas here they are contained only in particulars and are not published to the world at large, they are not the subject matter of the comment, but facts alleged to justify that comment. And that was the old common law position in 1951. And one can see that Section 6 is clearly a reaction to that. Of course, if the facts are derogatory to the plaintiff or defamatory of the plaintiff, then the common defence won't work. But that's not a reason for stigmatising the comment.
You say it's a much wider latitude than Section 5.
Yes, because there's no comparison of what you've got right with what you've got wrong. It's just the focus is solely on what you've got right. Have you got enough right? And as I say, as a matter of logic, that should be the only test that should be applied to opinion, because it just needs to have a sufficient factual basis. Any unfairness to the claimant can be addressed by his right to bring an action in relation to any defamatory statements of facts set out in the words. But if the words aren't if the facts aren't defamatory, it's just tough. It's no different from any situation where a false allegation of fact is published. There's been little analysis on this point until recently, but we do have two first instance decisions, Lowe and Associated Newspapers, and Rath and Guardian News and Media Limited.
Sorry, what's the second one called?
Rath.
R-A-T-H.
R-A-T-H, yes. I'm going to...
Just before we leave this,
Yes.
there's this rather striking passage in Lord Porter's speech a little further down. 20 facts might be given in the particulars and only one justified. Yet if that one fact were sufficient to support the comment so as to make it fair, the failure to prove the other 19 would not, of necessity, defeat the defendant's plea.
Yeah.
What was the test of fairness when Lord Porter said that?
Well, it was still the honest person test, which is, could an honest person, even if he was prejudiced or obstinate, hold the opinion on the basis of the facts? I mean, there may have been some argument about that in that time, whether there was a different test for base and sordid motives.
Yes.
Just looking further down.
Yes.
But subject to that one exception, comments were simply subjected to the honest person test by this stage. There was concepts of fairness, reasonableness had gone out the window. If they hadn't gone out the window then, they've certainly gone out the window now. I mean, we have Telnikov, decision of the House of Lords, where that's been made clear. Everyone is proceeding on the honest person test.
Well, the very next sentence suggests that it was the honest opinion test then.
Yes.
Yes.
But when one looks at this, it's quite clear what Section 6 was doing. It was giving the same tolerance for inaccuracy as was present in the common law by focusing on what you could prove. Is the comment fair by reference to those facts that have been proved?
I'm sorry, I mean, Lord Porter was envisaging that the facts alleged are not found in the libel, but in particulars delivered.
Yes.
I mean, but do you say that is faithfully reproduced in Section 6?
No.
I mean, Section 6 seems to narrow it.
Section 6, on one view, limits the type of case.
I know. Well, limits the, what you call the pool of facts.
Well, yes, and it limits the type of case as well. Because, and the limitation of the type of case will probably limit the pool of facts, because just going back to the section, I don't think your Lordship still have it open from Bundle 2.
It's also actually set out in the intervener's argument, both sections at page 32, but I mean, yeah.
The starting requirement is it's an action for libel and slander in respect of words containing two or more... it's an action for libel and slander in respect of words consisting partly of allegations of fact and partly of expressions of opinion. Now, Mr. Caldecott, I think, has something to say about that, in that it's unnecessary restraint. I don't need to make any submissions in that regard, because no one is saying that I haven't got an arguable case that I'm within Section 6, because this is an action which does consist partly of allegations of fact and partly of expressions of opinion. But there's certainly a strong argument to be had that there should be no limitation. I mean, any comment should simply be judged by the availability of facts that could sustain it, irrespective of whether there's any reference at all, and irrespective of the type of publication. And that's what Lord Leicester's bill seeks to do, sweep away all these requirements. The only requirement is that the words are comment, and there is somewhere a sufficient factual basis to sustain it. But it's clear that Section 6 is limited to actions where the publication complained of comprises partly allegations of fact and partly expression of opinion. So that could rule out quite a number of defamation claims, but it doesn't rule out this one.
No, but I mean, what is your submission on facts alleged or referred to in the words complained of? I mean, does that limit it beyond what Lord Porter was envisaging when he was simply talking about a whole series of pleaded particulars, which on the face of it didn't need to refer to the words complained of at all?
It does limit it, because it could be limited by reference to subject matter, as opposed to reference to the subject matter rather than reference to the facts in the words. If there's a reference to subject matter, then you can get all the facts that fall within that subject matter, without, even if those particular facts aren't referred to in the words complained of. So it does narrow the factual pool in that way as well. And there's certainly, again, an argument that it shouldn't be so limited. In my wider case, in the written case, I do submit, in accordance with Lord Leicester's bill, that simply be there should just simply have to, the defendant should simply have to prove the existence of sufficient facts or privileged information so that the honest person test is satisfied. There shouldn't have to be any particular reference. It must be implicit in the honest person test that the facts are germane to the comment. And that is implicit if an honest person is going to be able to hold the opinion on the basis of the facts. But beyond that, in my submission, there's no need for anything further.
You're not suggesting that "or referred to" is wide enough to embrace facts which you're now relying upon, which weren't actually expressly spelt out, but might have been inferred from the publication.
I'm sorry.
Having regard to such of the facts alleged, now that's obviously dealing with specific allegations, or referred to in the words complained of. Now it might be argued that "or referred to" in the words complained of simply means, or extends to cover, all the matters you're relying upon as being inferentially inferred in the publication, the background facts. And therefore, you can actually rely upon 6, even if everything that was written turned out to be false, provided that there is an inference that there's more to it than what's simply on the written page.
Yes.
Well, that's the once again scenario.
Yes.
That's the wording of statute. I mean, reference can be very brief. You're in no position to judge the validity of a comment just if a fact's been referred to. And the publisher doesn't even have to know anything about the fact for it to be referred to. I mean, the obvious response to the publication complained of could be, well, what's that breach of contract that 1311 are referring to? So there is criticism of Section 6 for its limitations.
So I'm not sure I can follow entirely. You have, it begins with talking about words consisting partly of allegations of fact and partly of expression of opinion. Now, when it comes on to talk about such of the facts alleged, is that referring to the allegations of fact?
Yes, the supporting facts for the comment.
Well, is it referring back to what in respect of words consisting partly of allegations of fact and partly of an expression of opinion?
I don't think it necessarily has to, but clearly the allegations of fact that are there could be relied on to support the comment. I mean, they are facts alleged. But I don't think it's stating that you could only rely on the allegations of fact that the claimant chooses to sue on. I mean, for example, you could have perhaps a wider article where only a small part of it is complained of, for example. I mean, that's a potential problem, which we're not faced with here. I mean, I haven't dealt with this in great detail for two reasons. The first reason is that it's accepted that, or it's not argued that it's not, a case involving words consisting partly of allegations of fact and partly of expressions of opinion. And secondly, I'm happy to base my case on the words referred to. I don't need to go wider than that and start asking the court to look at perhaps the subject matter of the comment as opposed to whether the particular facts were referred to, rather. I mean, reference to the facts is quite narrow. You have to look at the publication complained of, and you've got to look at the facts that are either set out there or referred to. If the test is you can rely on facts by reference to subject matter, then you can go beyond the publication complained of for your factual pool. You can go to facts relating to the subject matter of the comment, irrespective of whether they're alleged or referred to in the words complained of. You've got a wider factual pool, because the limitation here is your factual pool has to be alleged or referred to in the words complained of, whereas in Kemsley and Foote it was a much wider factual pool, and in Lower...
Well, Kemsley and Foote is an extreme example, isn't it, of a comment based on no allegation of fact whatsoever.
Not in the words complained of. I mean,
Lower than Kemsley, but that was the total alleged libel, wasn't it?
Yes. But it was there was a sufficient reference to the subject matter, which was the conduct of the Kemsley press. So that was a situation where there were no facts referred to in the words complained of in relation to the Kemsley press, but there was a reference to the subject matter. And as a result of that, the defendant was permitted to rely on facts set out in his defence concerning the conduct of the Kemsley press, even though those facts were not alleged or referred to in the words complained of. It's all about how far you widen the factual pool. And the only reason for narrowing the factual pool is if you want to be in a position where the reader can judge for himself that the comment is well-founded, because the further you allow the factual pool to roam beyond the words complained of, the harder it is for the reader to be in a position to judge the validity of the comments.
But if Kemsley had post-dated the 1952 Act, it would not have been caught by it, would it?
Possibly not.
Section 6.
Yes, because it wouldn't be...
Yeah.
It could not be said to be an action consisting partly of allegations of fact and partly of an expression of opinion. But it wouldn't need to, because the common law would be there in any event to give that protection, because as Lord Porter says, you can roam far and wide to get your facts, and you've got...
Well, sorry, you roam far and wide. It's going to depend entirely on the defendant's legal advisers, what they put in their pleading to justify the comment,
Yes.
is it not?
Yes.
I mean, it's up to them how far they're going to roam, and if they roam too far, they'll be struck out. I mean, that's the position, isn't it?
Well, they can roam... Well, if they roam... The only too far would be if it wasn't relevant to the subject matter of the comment, which is quite a wide range of factual material, assuming it exists. And bearing in mind that the test is extremely low, the honest person test is not very hard to satisfy. I mean, there are potentially other restrictions, such as whether the facts were known to the commentator at the time of the words complained of, whether they were in existence at the time that the words were published. So there's some other restrictions on the factual pool, but in terms of reference, the only restriction on reference is that there's a reference to the subject matter, not to the facts. That is the position at common law, where the words are not set out in the publication complained of itself. Where the publication itself consists of factual allegations and expression of opinion, it's governed by Section 6. And the extent of the defendant's factual pool is governed by what facts alleged or referred to in the words complained of he can prove. That's how far he can go. And that's what my client is seeking to do in this case. He's seeking to resort to facts that have been referred to in the words complained of. And he's therefore entitled to take advantage of Section 6. And no one has ever said that he's not. There's never been any finding or any suggestion that we're not potentially in Section 6 territory on the facts of this case.
This is an action liable in respect of words consisting partly of allegations of fact, partly expression of opinion. That's the contention, is that right?
Yes. We have to assume that we're within the section, because no one's saying that we're not. I pleaded it in my defence. No one's tried to strike it out. So we're within Section 6, and because of that, it's the three-stage approach. What are the facts alleged or referred to? Have they been proved? And could an honest person express the opinion on the basis of the proved facts? There'd be different considerations if I was pleading in my particulars of fact something that wasn't referred to in the words complained of, something which perhaps is simply referred to by subject matter, some general allegations relating to the band, for example.
Relating to what?
Relating to the band, some more general allegations relating to the band.
So you're saying, I mean, you could still then plead the defence, but you're simply not entitled in that situation to the benefit of Section 6. Is that the point?
Yes. That if you're dealing with an action which does not consist partly of allegations of fact and partly of expressions of opinion, you can't rely on Section 6, because that is the entry level for this particular piece of tolerance to factual inaccuracy.
But Section 6 is there to help defendants.
Yes.
I mean, there may be situations where they're not entitled to it, but that doesn't mean they still don't have a perfectly valid fair comment defence.
No.
Section 6 is there to deal with the bit which occurs at the very top of page 358 in Lord Porter's judgment, where he says if you fail on one bit, a little bit of fact, then you're out.
Yes.
That's what it's here to
Yes,
help.
but it does go further than that, because it could have said, if you fail on one immaterial fact, it seems ridiculous for you to lose your fair comment defence. But what Parliament could have done is they could have set a midway point, which is if you don't get your basic facts right, or if what you've got wrong is material to the comment, then you'll lose your comment defence. So Parliament could have introduced some form of comparison between the proved facts and the unproved facts. In Kemsley, Lord Porter's talking about an immaterial fact. But there could be a halfway house where some facts were proved, some facts were not proved, and the facts that were not proved were material in the context of what was proved. Parliament hasn't done that. Parliament has avoided any comparison of the proved facts against the unproved facts, and the test is to be judged solely in relation to the proved facts, which is in contrast to Section 5, which is in relation to justification, where there is a comparison. And that reflects the nature of defamatory factual allegations as opposed to defamatory comments, where the balance between protection of reputation and freedom of expression must be struck more closely towards protection of reputation because of the damaging effect of defamatory factual allegations. I was going to go to Lowe and Rath, which are two recent decisions where first instance judges have considered these issues. Lowe is in bundle 1.
But could I just ask, I'm sorry to ask this, but supposing all you had said, all that they had said was, we would recommend that you take legal advice before booking this artist to avoid any possible difficulty. That's all.
Yes.
Could they have then brought in anything to justify that? In other words, all these old pieces of history and so on.
Yes.
So we're being to the other part of what Lord Porter says, because they're not making any specific.
Yes.
Is that right?
Yes. I mean, there might be an argument about whether the words were fact or comment in that situation, because it's said sometimes that a bare statement without any facts could be treated as a statement of fact. Yes. I mean, I've always had problems with that as a concept. I mean, I think that if you say, we recommend you take legal advice for this band, I mean, that's self-evidently a statement of opinion. Yeah. But, I mean, the American cases, I think, look at it on the basis that a statement of opinion such as that would imply some statement of fact. So it would come with it would be an inference that they're untrustworthy, that they've breached contracts. Well, untrustworthy could be an opinion, but let's say that they have conducted themselves in the past in a particular way. And these are all difficult problems. On one level, in my submission, this is actually quite a straightforward case, because we do have a publication which falls quite clearly within Section 6, absolutely smack bang within it, and we have an obvious reference to the facts on which my client seeks to rely, and no suggestion that the honest person test couldn't be satisfied on those facts. And not only that, we've also got a full-blown justification defence which has survived intact, in contrast to London Artists and Littler. So it's frankly amazing that my client's fair comment defence has been struck out in these circumstances. I was going to go to Lowe and then to Rath. Lowe is at tab 23 of bundle 1. It's a decision of Mr. Justice Eadie in 2006, where the allegation was that a takeover of a football club was a repellent piece of financial chicanery. And there were the main issue there was whether the defendant could resort to the facts that it wished to do in its defence, and the claimant said that it was going far too wide. Mr. Justice Eadie said that the correct test was by reference to subject matter, and in relation to that passage from Lord Porter in Kemsley, he said this, and it's at paragraph 35. Whether such a stark distinction will be drawn today between facts stated and those pleaded is open to question. I would be surprised if it were now to be held that the omission to establish one important fact would lead to the overall failure merely because it had been stated in the article. That would appear to be inconsistent with the policy underlying the rule with regard to justification, that words complained of need only be shown to be substantially accurate. I can see no principal distinction in this respect between the two defences. Moreover, I should be surprised if the proposition was to be found compatible with Article 10 in the Strasbourg jurisprudence, which generally allows leeway for journalists in the exercise of their trade, so as to accommodate a degree of inaccuracy and exaggeration.
This is common law, this is not Section 6.
Yes, no reference to Section 6. I'm taking the court to this for completeness, and I also observe in passing, with respect to Mr. Justice Eadie, that to draw a comparison with justification is too strict on comment. The facts may have to be substantially accurate where justification is concerned, but they simply have to be sufficiently accurate where comment is concerned. Mr. Justice Eadie refers to the Strasbourg jurisprudence, but it's clear from that jurisprudence that a value judgment, which is how the court describes comments, will only be excessive where it has no factual basis. Mr. Justice Eadie analyses the authorities and then reaches his conclusions at paragraph 55. Which is on page 599 of the report, where he says this: I conclude, after considering these older authorities in some detail, that they are consistent with two particular principles which I've already highlighted in the House of Lords speeches in Kemsley and Foote. One, if the facts are stated in words complained of and are wrongly stated, this will undermine the defence of fair comment. Two, a defendant is not precluded from pleading extrinsic facts in support of a plea of fair comment. They also support the proposition that readers need to be able to distinguish facts from comment for the defendant to be permitted to rely upon the defence of fair comment. A bald comment may, in circumstances where it's not possible to understand it as an inference, is likely to be treated as an assertion of fact, which will only be susceptible to a defence of justification or privileged. Where facts are set out in the words complained of so that the reader can see that an inference or opinion is based upon them, then the defence of fair comment will be available, but the defendant is not tied to the facts stated in the article. He may invite the jury to take into account extrinsic facts known to the writer as part of the material on which they are to decide whether a person could honestly express the opinion or draw the inference. While it's necessary for readers to distinguish fact from comment, it's not necessary for them to have before them all the facts upon which the comment was based for the purpose of deciding whether they agree with the comment or inference. I draw that conclusion with all due diffidence, since Lord Nichols has twice expressed the opposite view. But it does seem consistent with principle, and in particular with the undoubted rule that people are free to express perverse and shocking opinions and may nevertheless succeed in a defence of fair comment without having to persuade reasonable readers or the jurors who represent such persons to concur with the opinions. It's difficult to see why it should matter whether a reader agrees. What matters is whether he or she can distinguish fact from comment. Sometimes that will be possible, as it was in Kemsley and Foote, without any facts being stated expressly, because either they are referred to or they're sufficiently widely known for the readers to recognise the comment as comment. The suggestion in paragraph 55 that if the facts are stated in the words complained of and are wrongly stated, this will undermine the defence of fair comment, is, in my respectful submission, inconsistent with what Mr. Justice Eadie said earlier about tolerance of factual inaccuracies, and inconsistent with Section 6, where a case falls within Section 6. The next case is Rath, and this was included in the Court of Appeal's judgment in the present case. Rath is to be found at tab 30 of this bundle. It is a first instance decision of Mr. Justice Tugendhat, and the publication complained of was an article in the Bad Science column of The Guardian, which included an allegation that the claimant was peddling vitamins to AIDS victims in South Africa. In other words, selling them, profiting from them, on the back of false claims that his pills were better than the antiretroviral drugs, and that this had caused hundreds of thousands of people to die. And in fact, the claimant gave away these pills. He didn't sell them. That was said to be the material misstatement of fact. What was the relevance of that to the comment defence? Mr. Justice Tugendhat analyses this on from paragraph 66 onwards. I'm sorry there's no page numbers. So he analyses the factual inaccuracy. He then goes to London Artisan Littler, which I was intending to go to a little bit later. And then he cites the passage that we've just seen from Lord Porter, which is at paragraph 76. That passage was relied on by counsel for the claimant, as was the two passages from the judgment of Mr. Justice Eadie in Lowe. Those are referred to in paragraphs 78 and 79 of the judgment. And in paragraph 81, he records the submission of my learned friend Mr. Caldecott, who says this: as to the law, Mr. Caldecott submits that Kemsley and Foote is no longer authority for the proposition for which Mr. Nicklin invokes it at this stage of the argument. It has been overtaken by Section 6 of the Defamation Act 1952, which was passed in the same year as the House of Lords delivered their speeches. The hearings had been in 1951, the speeches were delivered in February 1952. He submits that Section 6 applies because this is an action for libel in respect of words consisting partly of allegations of fact and partly of expression of opinion. It follows that the defence of fair comment will not fail by reason only that the truth of every allegation of fact is not proved if the expression of opinion is fair comment having regard to such of the facts alleged or referred to in the words complained of as are proved. Mr. Caldecott submits the law as expressed in Lord Nichol's third principle, which was itself a summary of what Lord Denning said in Littler. Mr. Justice Eadie's reservations about Kemsley and Foote were correct, although it's not necessary to go to Article 10 to reach that result. It is already enacted by Section 6. Mr. Nicklin submitted that Section 6 would not have applied to the words complained of in Kemsley and Foote, because in that case the words complained of did not include an allegation of fact. So I should not read Section 6 as qualifying what was said in Kemsley and Foote. He submits that the very experienced counsel in Lowe and Associated did not apparently refer Mr. Justice Eadie to Section 6, and they were right not to do so. Conclusion. In my judgment, the defendants have a real prospect of showing this case is within Section 6 of the Defamation Act 1952, and I do not have to consider the case of a plea of fair comment that it is not within that section. Mr. Justice Eadie did not have to decide in Lowe and Associated to the point that I am being asked to decide. The defendant does have a real prospect of success on the issue of fair comment. I have already held that he has a real prospect of success in establishing the allegation in question is comment, and whether or not he succeeds in overcoming the claimant's point the facts are not truly stated depends on whether, in accordance with Section 6, the expression of opinion is fair comment, having regard to such of the facts alleged or referred to in the words complained of as are proved. My submission that is entirely the correct approach and the approach that should be applied to the facts of this case. But there is, I respectfully submit, one error in the judgment, and it's in the passage that was cited by the Court of Appeal in the present case, which is paragraph 88, just a little bit further on. And before I just read it, I'd make the point that this case again came before the court at the interim stage. So it was a question of preempting perverse jury findings. Mr. Justice Tugendhat says this: but in the present case, for the reasons given by Mr. Caldecott, I cannot conclude that defendants have no real prospect of proving any of the statements of fact upon which they rely. I do not think it right at this stage of the proceedings for me to decide whether the fact that the claimant donates rather than sells vitamin pills makes the statement that he sells them wholly untrue or only partly untrue. And assuming that the statement is either wholly or partly untrue, the significance of that in the context of Section 6 and the other facts set out at paragraph 63 above does not appear to me to be sufficiently clear for me to make a ruling at this stage. And in those circumstances, I cannot conclude that defendants have no real prospect of succeeding in their plea in reliance of Section 6, that is, of failing to establish that the words not proved to be true do not materially injure the plaintiff's reputation having regard to the truth of the remaining charges. That is an issue that in the present case cannot be disposed of at this interlocutory stage. And with respect, the error is in the penultimate sentence, because what Mr. Justice Tugendhat has done there is to state the test in relation to Section 5. The correct test in relation to Section 6 was set out in paragraph 84 of his judgment. What he's brought into the penultimate sentence of 88 is a comparison between the proved facts and the unproved facts, and whether they materially injure the plaintiff's reputation. But that is not the test.
But you said that the Court of Appeal cited this, and that's perfectly true. They cited it, paragraph 41, by reference to submissions made by you, I think. It says, on the facts of that case, the judge referred, this is a paragraph 41 of their judgment.
Yes.
They then quote paragraph 88, but then they don't seem to do anything with it.
No.
So it's not at all clear that it did actually affect the reasoning.
No, but it was never applied. The honest person test was never applied because there were never any facts that I was permitted to rely on for it to apply. I mean, before you even get to that test, you'd have to have a look at the words that have been proved to be true as against the words that haven't been proved to be true. But there was no analysis of what allegations I could prove to be true, because I wasn't allowed to rely on any of them for reasons that were simply not argued in front of the Court of Appeal. So the test at the interim stage is whether there's a real prospect of the defendant persuading the jury that the honest person test can be satisfied on the basis of the facts that he's entitled to rely on. And nobody in this case is saying that if my clients are entitled to rely on paragraphs 9.3 to 9.15 of the amended defence, he cannot satisfy the honest person test. The honest
Mr.
person...
Price, I'm sorry, I mean, are you saying that 9.1 to 9.15 in your pleading, those are all facts that are alleged or referred to in the...
Yes.
You are.
And there's never been any application by the claimants to say that they're not. The pleading alleges that they are sufficiently identified in the words complained of.
But, I mean, I'm sorry, to assume that to be right, I mean, is the Court of Appeal's judgment inconsistent with that?
Yes, because it's the Court of Appeal preventing me from relying on facts that I want to rely on to sustain the comment.
But is it doing it by reference to this language of Section 6?
Yes. It's saying that the breach of contract, the Bibis breach of contract, is not referred to.
It's because it's too soon and disconnected.
Well, no, the Bibis one is not referred to. The Bibis one is the re-engagement term.
I'm sorry, the lamp.
Yes.
Yeah, I'm sorry.
No, the Bibis term is not, the Bibis breach of contract is not referred to in the words complained of. That is the Court of Appeal's finding. Therefore, I cannot rely on it. In terms of the email of the 27th of March, there was no analysis about whether the email as a whole was relied on, because there was no argument about it. It's clear from the amended defence that I deconstruct this email quite carefully to show why it demonstrates a contemptuous approach to contractual obligations. Now, the analysis of the Court of Appeal ended on the basis that there was a misquotation in those particular words. The Court of Appeal didn't go on to ask whether I should be entitled to rely on the email as a whole as part of the factual pool for the comments. That was simply not argued. But my pleaded case was that email was referred to in the words complained of. And there was no application by the respondents to strike out that allegation. And whether words are referred to in the words complained of is a question of fact for the jury at trial.
Where exactly is your reference, just so we see it? Where is it you say that they're referred to in the thing?
In the pleading?
Yes.
Yes. It's tab 6, and It's paragraph 10.2.
Well, it's 9.12, isn't it?
Yeah, it's 9.12 refresh, but...
Yes, I mean, the allegation, yes, 9.12 deconstructs the email, and 10.2 is the averment of reference. I mean, I've put sufficiently identified because there is debate about precisely what level of identification you need, but that was put there to effectively state whatever the test is, there was a sufficient identification of the facts for them to be relied on. Now, if one looks at the application notices, there was never any application that was before the court coming from the respondent saying that is a bad plea. There's no way that these things were sufficiently identified because it was a bare reference. You didn't identify the contract. There was no application that Section 6 of the Defamation Act was not available to my client. The respondent's notice that we got was fairly brief. Might be helpful just to have a quick look at it. It's at tab 16. And it's right at the end of tab 16, page 110 of the bundle, and it's really 1.1. Quotation attributed to the first claimant, contracts hold no water in legal terms, and the words complained of is arguably false, and thus particularly given that it's fundamental to the words complained of renders a fair comment defence unsustainable. So that was the only argument before the court. I identified at the start of my submissions two relevant points here. First of all, were the allegations in paragraphs 9.3 to 9.15 of the amended defence sufficiently identified within the words complained of? Secondly, what's the relevance of the misquotation? But it was only the second point that the respondent raised. I'm having to deal with it now because it found its way into the Court of Appeal's judgment.
Are you addressing paragraphs 38 to 40 of the Court of Appeal's judgment now? Or are you on another point? I'm getting a bit lost.
Yeah, I'm sorry. I was trying to take it and deal with the legal principles and then apply them to the facts of the case.
Yeah, but what is the point that you say you had to deal with, which you didn't think you had to deal with? Is it in paragraphs 38 to 41 of the judgment, or is it somewhere else?
Well, I had to deal now before your lordships with paragraph 42 of the judgment, which is there's no reference to the Bibis breach of contract in the words complained of.
But I think on the email point, it's paragraph 38, isn't it?
Yes, but that's only dealing with one issue, one aspect.
Well, the point I was going to make to you, and quite quickly, is if you are on paragraphs 38 to 41, I don't think the Court of Appeal was against you. Paragraph 38, Lord Justice Pill says, I have more difficulty with this issue about it being contracts in general, not a particular contract. He refers to Lord Oaksey in the pre-Defamation Act case, got untruly stated. Then in paragraph 40 he says, however, and then he gives you the benefit of section 6. And then in section 41 he refers to Wrath in order to give a second reason for being in your favour, that is that it's not appropriate at an interlocutory stage to decide this because it's going to depend on context. Although he actually leaves out of the quotation from Wrath the important words about the true significance is not sufficiently clear for me to make a ruling at this stage. And then he goes on in paragraph 42 to the real complaint. Is that the way you see it?
Well, he is. I mean, he's not with me.
I'm trying to assist you, but if it doesn't assist you, leave it. That's the way I read the judgment.
I mean, perhaps I'm being a bit daft, but I don't think he assists me in paragraph 38 because he doesn't go on to ask or consider the email as a whole. He stops, the analysis stops.
But you don't take it one paragraph at a time. 38, he identifies a problem. 39, he says why it's a problem. 40 and 41, as I see it, he says, but it isn't really a problem. And that's the end of that point. And he then goes on to what he calls the real complaint.
But for this defence to be struck out, the court would have to ask itself, could a jury properly conclude that the honest person test was satisfied in relation to these comments? And that would involve asking that question by reference to certain facts. It couldn't be asked in isolation. That question is never asked by the Court of Appeal other than in relation to the landmark breach, which was the most minor, probably, of the allegations that were relied on. The only time that the court analyses this in terms of the honest person test, or it doesn't even do so explicitly, is in paragraph 46, where he says a jury could not properly base a finding of fair comment against the claimants given the nature of the comment upon a breach of contract in December 2005. He doesn't ask himself, could a jury properly base a finding of fair comment against the claimants on the basis of that email of 27th March when viewed as a whole? One has to approach this in a principled way, and that involves pleadings which set out allegations which are viable unless they've been struck out. So one would have to go through every single particular in paragraph 9 to ask whether they are properly relied upon in support of a comment defence. And then, having worked out what is properly relied on in support of a comment defence, one would have to ask the honest person test by reference to those particulars, bearing in mind that the role of the court is to preempt perverse jury findings, and that analysis simply never happened in this case. And one of the reasons it didn't happen was that there was no issue before the court as to whether I was entitled to rely on all those particulars, whether they were properly referred to. It simply wasn't before the court. But the Lord Justice Pill, in his judgment, took it upon himself to find that there wasn't a reference to the Bibis contract, and didn't ask himself whether there was a reference to the entire email and what could be drawn from that email. He also, with respect, appears to have decided a question of fact rather than approaching it from the perversity test, certainly in relation to whether something was referred to in the words complained of. What I'm seeking to do is to submit by reference to Section 6 and by authority that the only relevance of a falsely stated fact as far as fair comment is concerned is it requires the defendant to resort to at least one other fact that's properly referred to or identified and which is capable of satisfying the honest person test. That's my submission. That's why I've gone to what was said in Kemsley and Foote. I've gone to Section 6. I've gone to what Mr Justice Eadie said in Lowe, and then to what Mr Justice Tugendhat said in Rath, because these are the most recent decisions. And subject to that one error in Rath, in my submission, the approach of Mr Justice Tugendhat is quite correct in a Section 6 case.
So I'm still not clear in my own mind. Could we look at the facts and issues, just because there we get the posting? Look at paragraph 7 of that, where we get the posting. What do you say is the reference to the email? Where is it referred to? Where do you refer to? That's in terms of Section 6.
Craig Joseph, who runs the Gillettes and Saturday Night at the Movies, has advised 1311 Events that the terms and contracts of conditions holds no water in legal terms 270307.
That's the reference.
That's a reference to a communication.
So that's the whole thing. That's it.
I mean, let's put it another way. In a document, Craig Joseph, who runs the Gillette's at Saturday Night at the Movies, had advised 1311 events that the terms and conditions of contracts hold no water in legal terms 270307. If that was put in a statement of case and there was an application under CPR 3114 on the basis it had been referred to, the document would clearly be disclosable. It is a reference to a communication. One doesn't know whether it's a written communication or an oral communication, but one rather thinks it's a written communication. But it's clear from that, or a jury could properly conclude from that, that that is a reference to a particular communication.
It's just, that's where you get your reference.
Yes.
Yeah.
It's got the date to it.
Yes, no, I see that.
Yes. Could a jury, without being perverse, conclude that that was referring to a particular communication? And it would also be absurd if you misquoted something from a document, but the rest of the document completely sustained your case, obviously sustained your case, but somehow you weren't allowed to rely on it because of a quotation in the bit that you did set out. That would be the sort of technicality and artificial result that has brought the law of libel to the state in which it's in now. And where Lord Denning talks about the need to get away from the technicalities, the restrictions that afflict this particular defence. But it's clear the Court of Appeal didn't make a finding that that email was not referred to. I was just going to deal now very briefly with the honest person test, what that actually involves, and then deal with Cheng. And then at that point I was going to analyse the principles by reference to the particular facts in the Court of Appeal judgment, although I've probably touched on that to quite a large extent already. So one has the facts that are referred to, one has the facts that have been proved. What does one do next and finally? One asks whether judged objectively, an honest but possibly prejudiced and obstinate person could hold the relevant opinion on the basis of those facts. That must be an extremely low hurdle for a defendant to surmount. And that must be an even lower hurdle at the interim stage, where the issue is whether a reasonable jury could properly conclude that an honest person could hold the relevant opinion. The Fawkes Committee recognised it's the very latitude which is given to the notional honest opinion to express unfair and unreasonable opinions, which enables the defence to perform its role as a bulwark for freedom of speech. The reality is that people can honestly believe many things on a very scant factual basis, without any form of rational analysis, particularly if they're prejudiced and they're obstinate, as they're entitled to be. So, with those principles in mind, Section 6 in mind, one considers what Lord Nichols said in Cheng, and in particular whether the reader needs to be in a position to judge whether the comment is well-founded. Cheng was a decision of the Hong Court Court of Final Appeals. Lord Nichols gave the leading judgment, and he set out what he regarded to be the 5 elements of the defence of fair comment. It may be easier to we can either go to Cheng or we can look at it from the judgment of the Court of Appeal. At this stage, I'm just going to deal with those 5 principles. Cheng was not a case about the interrelation between fact and comment. It was a case about what is meant by malice in terms of fair comment. And it was only in passing that Lord Nichols made these observations. Perhaps we should go to the case itself, just so the court can see what was in issue in that case. And it's in volume 2 of the authorities bundle at tab 62. This all arose from the arrest of a tour escort for smuggling drugs. Campaigns were commenced to suggest that his arrest and subsequent imprisonment was unfair, that he was an innocent man. He was eventually released, and various people claimed the credit for his release. He was working for a company at the time, and This was a criticism of the company solicitor in relation to the advice that he'd given to the person who'd been released. The criticism being made by somebody who ran a campaign for the release and was said to have been motivated generally against the solicitor claimant. And the issue was whether malice in the context of fair comment was limited to absence of honest belief, or whether it could cover a dominant improper motive, as it does with qualified privilege. And the finding of the court was no, malice is limited in the context of fair comment to an absence of honest belief. That's apparent from the head note. It was within this context that Lord Nichols set out his 5 ingredients, which he described as non-controversial, at paragraph 16 onwards on page 782 of the judgment. And he said there were 5.
Sorry, which paragraph?
Paragraph 16, page 782.
Yep.
So the first is public interest, not an issue here. Second, comment must be recognisable as comment, as distinct from an imputation of fact. If the imputation is one of fact, a ground of defence must be sought elsewhere, for example, justification and privilege. The third, paragraph 18, third, the comment must be based on facts which are true or protected by privilege. See, for instance, London Artist and Littler. If the facts on which the comment purports to be founded are not proved to be true or published on a privileged occasion, the defence of fair comment is not available. Now, that paragraph I'm going to analyse a little bit further on, but for the moment it's number 19. Next, the comment must explicitly or implicitly indicate, at least in general terms, what are the facts on which the comment is being made. The reader or hearer should be in a position to judge for himself how far the comment was well founded. This is one of the questions of law of public importance that is before the court at the moment. And I do respectfully submit that the second sentence of Cheng, if it's treated as a requirement or a goal towards which the law should strive, would severely restrict the ambit of the defence of fair comment. And it cannot apply to cases where a defendant is entitled to rely on Section 6. Section 6 was not an issue in this case. And I don't know whether there was an equivalent provision. But in any event, the case was about malice, and these were just summaries of the law.
Do you accept the first sentence, or do you challenge that?
Well, it's an oversimplification, if I may respectfully submit, and it can't apply in a Section 6 case. This is the first sentence of 19.
Yes.
Well, my submission is that's not necessary. Shouldn't be necessary. But I don't have to go that far, because on the facts of this case, there clearly is a sufficient reference to the factual material on which I wish to rely. If this poses a requirement which is greater than the requirement in Section 6, which is to allege or refer to the facts, then it can't be right. It can't impose a higher test than Section 6, which is...
Does Lord Nichols touch on Section 6? I mean, it wouldn't apply in Hong Kong either way, but I mean, does he touch on it?
No.
Is there any support in authorities to which reference is made in this decision to this for the second sentence in paragraph 19?
No. And Duncan and Neil concludes that, in fact, it doesn't reflect authority. And there's certainly no authority explicitly cited to support that proposition.
You're going to show us the academic or textbook comments on this, are you?
Yes.
It can't extend to the review of a first night
No.
In the theatre.
No. Impossible. This is an appalling
Particularly
play.
if it was in New York.
This is
Probably wouldn't sound in any damage in this country.
This is an appalling play. Don't go and see it.
Yeah.
I mean, that could be terribly damaging for the play, for the production team. Negative reviews can cause massive financial loss, but there's no way that the reader can judge the validity of the comment without going to see the play, which he's not going to do after he's read a review like that. This is why this point is so important, because go on the internet, go onto any bulletin boards. Most people, if they go out to a restaurant, they might go to London Eating or Top Chef or whatever they're called, and they'll just see opinions. Sometimes they may have some facts set out, but often they won't. But one thing's absolutely for sure, if you have not been to that restaurant, if you have not seen that play, you're really in no position to judge the validity of the comment. But lots of people's decisions are based on this. In the United States, it is suggested that this should all be fought out in the marketplace. That it's through debate, it's through unrestricted expression of opinion that the correct opinion, if there is one, can come out. The validity of an opinion can be tested by debate, not by libel litigation. So,
do we get any clue where Lord Nichols got the idea of that second sentence from?
I'm not sure that I do. It may be that he regards it as a consequence of the first. At least to the extent that the reader or the hearer has the means to...
Sorry, what are you reading?
Well, I'm unaware of any basis for that second sentence, but maybe what Lord Nichols is saying is that it's a consequence of the first sentence of paragraph 19. In other words, if you explicitly or implicitly indicate the facts, then the reader can judge for himself. If he can't judge for himself by looking at the publication complained of, maybe he can try and find out some more, and there's a steer to what he can look to, if he wants to find out whether the comment is valid. But people aren't going to do that, and it's an unrealistic goal to set. And if it is there as a principle, it's going to limit the defence quite considerably. I mean, you have to have a jury question, which is, was the reader of this comment in a position to judge whether it was well founded on the basis of the material that was put before him?
I mean, the oddity is that Lord Nichols introduces this five-fold test as non-controversial,
Yes.
well established.
Yes.
But in the real world, I mean, are juries directed in accordance with the second sentence of paragraph 19?
Not so far as I'm aware, no. I mean, in the real world, defendants rarely get fair comment defences to trial because it's such a difficult defence to run. And you stand a big risk of losing, for example, on the basis that the words are fact rather than comment. Maybe there's some possibility, some other defamatory factual allegations in the words complained of. But there are very few cases that go to a jury on fair comment. I'm unaware of any jury ever having been directed in terms of that second sentence of Cheng. I did have a case which I've referred to. It's in the bundle, a case called Thornton and Telegraph Media Group Limited, which has come before the court on a number of grounds recently. But Sir Charles Gray struck out a comment defence to a book review in part on the basis that the reader would not have been in a position to judge whether the comment was well-founded. Now that's gone before the Court of Appeal. And there's a pending application for permission to appeal. That is certainly one situation where that principle has been applied with the consequence that a fair comment defence has been struck out. I'm unaware of any jury direction to that effect. Mr. Justice Eadie is, of course, the judge in charge of the jury list, and we can see from Lowe that he is of a different view to Lord Nichols. And clearly the principle can't apply in a Section 6 case anyway. One can see the reason why it's there. It's perceived to be a safeguard to the protection of reputation, because what can happen is that people can form an adverse view on the claimant as a result of an opinion which on its face looks as if it may be well-founded, but actually turns out not to be. And therefore that could be said to be unfair on the claimant. Whereas if all the material is there, even if it is an unreasonable belief and an irrational belief, the reader can see that and won't take against the claimant in the same way as he might if all the factual material wasn't made available to him so he could make a judgment on the validity of the comment. I can see why it's there, but if it's there, it's extremely onerous. And the result would be, I mean, every time a comment defence is lost for some reason, other than the words are fact, the consequence in Article 10 terms is that a value judgment becomes impugned and damages are payable in relation to a value judgment, which the Strasbourg court consistently says is contrary to Article 10. So if there is factual material that can sustain the comment, but it's not set out exactly in a way that enables the reader to judge the comment, if that's a requirement, the defendant's going to lose and he's going to have to pay damages. That's why at the beginning I talked about having to proceed in a principled way where everyone knows where they stand. What are the requirements of this defence? I submit it's simply that the words are comment and there is a sufficient factual basis to satisfy the honest person test. And that's very simple. It may work some form of injustice in that some people may come away with a harsher view of the claimant than is warranted, but that's a necessary price for freedom of expression. But in any event, we have Section 6, which of course is binding on this court, and unless it's incompatible, and even then it's, Section 6 is clearly not going to be the subject of a declaration of incompatibility. Section 6 merely requires the facts to be alleged or referred to in the words complained of. That cannot be a qualification. So the words explicitly or implicitly indicate in Cheng cannot be a qualification or an additional hurdle to the Section 6 test. Telnikov and Matusevic was the last time that the defence of fair comment was heard by the House of Lords. And there is
which
some...
case?
Telnikov.
Are we looking at that?
Yes, there is some reference to this in Telnikov.
Where's that?
That's in volume 1 at tab 36. In common with Cheng, this was not a case about the relationship between fact and comment. It was a case about whether the words were fact or comment, which is the first question. The issue here is whether the defendant was entitled to rely on the terms of an article which preceded the publication complained of in determining whether the words were fact or comment. The claimant wrote an article which was critical of the employment policies of the BBC's Russian service. This prompted a letter to the Telegraph, where the article was published, accusing the claimant of anti-Semitism. And if the letter was read in conjunction with the article, it was clear that the relevant allegations were comment. The issue was, can you read the article? Can you read the letter with the article, or do you just have to look at the letter as that's the only thing that's complained of? And the House of Lords held that you have to just look at the letter complained of in order to determine whether the words are fact or comment. You can't look at it in the context of the claimant's article. Lord Ackner dissented on this particular issue. And in doing so, he said this, page 361A.
Again, Lord Ackner's dissent.
Yes. I don't think any of the other speeches really say anything about this issue. But Lord Ackner was making the point in the context of meaning, because what the majority said was, well, look, lots of people who read this letter where the claimant's being accused of anti-Semitism would not have seen the original article. So they wouldn't be able to recognise the allegation as one of comment. You have to just assume the readers have read the letter without reading the preceding article. And the Court of Appeal took a different view. I'll go briefly to the Court of Appeal decision afterwards. But what Lord Ackner said, 361A, is, I share the view expressed in particular by Lord Justice Wolfe, that if the court is not entitled to look at the material on which it is alleged that the words complainable commenting, it would unduly restrict the defence of fair comment. Indeed, it would diminish and impair this vitally important right by whittling it down by a wholly unjustified legal refinement. If the criticism of an article published in a newspaper on a subject matter of public importance is to be confined to the passages actually set out in the criticism, then the freedom to comment on a matter of public importance becomes, from a practical point of view, illusory or non-existent. The ability of a defendant to comment should not depend on whether or not the reader is aware of the material which is the subject of the comment. As pointed out in terms by Lord Justice Wolfe, the defence of fair comment is based on the principle that a citizen should be entitled to comment on a matter of public interest, and the fact that the publication is limited does not affect the public interest. In my judgment, the defence of fair comment is not based on the proposition that every person who reads a criticism should be in a position to judge for himself. It would be absurd to suggest that a critic may not say what he thinks of a play performed only once because the public cannot go and see it to judge for themselves. The defence of fair comment is available to a defendant who has done no more than express his honest opinion on publications put before the public. It's sufficient for him to identify the publication on which he's commenting without having set out such extracts therefrom as would enable his readers to judge for themselves whether they agreed with his opinion or not. Were the law otherwise, it would be necessary, or at the very least forensically expedient, to set out ipsissima verba the entire contents of the article on which, as a matter of public importance, the citizen is entitled to comment honestly. In the result, the important contribution to public discussion on matters of public importance arising out of the publication in the press of correspondence will be seriously curtailed, yet a free and general discussion of matters of public interest is fundamental to a democratic society. Turning back a tab, one can see what Lord Justice Wolfe said. It's at the end of the judgment of the Court of Appeal, page 123C.
Sorry, I'm a bit lost. I mean, you're commending to us a dissenting view of Lord Ackner, is this it?
I am, yes. Because
But I mean, oughtn't we just at least notice what the view of the majority was?
There's nothing inconsistent with that principle in the view of the majority in my submission. It was just a reason given by Lord Ackner for his view that one had to construe the letter in the context of the article. So the main speech is Lord Keith, and it starts at page 349.
Where does he express some view apparently contrary to that you've just shown?
Well, he doesn't...
352E, is it?
353.
Yes, that's his reasoning on the point that's before the court. But he doesn't provide as a justification for that principle that the reader has to be in a position to judge whether the comment is well-founded, because it's a different issue that's being considered there. The issue that's being considered there is whether the words are fact or comment.
This is the end of the paragraph.
He accepts that on the issue of whether they are fair comment, one can go to the facts in the first publication, namely the article, even though readers of the letter might not have seen the article. So, in other words, if the defendant had qualified his words in the letter to make it clear that he was expressing an opinion, he would have been able to resort to the text of the claimant's article to provide the factual basis for the defence, even though readers would not necessarily have read the article. And what Lord Ackner is saying is, well, if you allow them to do that, why not allow them to do it for the purpose of construing the article? All this is apparent from the passages on 352 and 353. And in particular, it's said on page 354, following the reference to Kemsley. 354b, Lord Keith says, all that was said in the context in which the words complained of were admitted to be pure comment, and the passage therefore has no application to the present case. There can be no doubt that where the words complained of are clearly to be recognised as comment, and the subject matter commented on is identified, then that subject matter must be looked at to determine whether the comment is fair. Kemsley is no authority for the view that the subject matter may be looked at for the purpose of turning what on the face of it is a statement of fact into a comment. The subject matter may, of course, be looked at for the purpose of ascertaining that the statement of fact is untrue. And then there's a reference to Merivale. So the House of Lords there are just considering the first stage, are the words fact or comment? But if they are comment, then you can go beyond the publication into material that the reader of the publication may be unaware of. So that passage that I took your lordships to from Lord Ackner's speech is not inconsistent with what Lord Keith is saying. It's just a dispute as to the materials that you can rely on in terms of construing the article. Everyone accepts that once you've got over whether the words are fact or comment, once they're comment, you can go into material that may not have been read by the publishees. And that was the rationale of Lord Justice Wolfe in the Court of Appeal. Can I just briefly go to Lord Justice Wolfe in the Court of Appeal?
Yes.
It's the last page of the report in the preceding tab, page 123 of the Queen's Bench report at C. Lord Justice Wolfe says this: in coming to my conclusion that you are entitled to look at the article in deciding whether the words complained of are statements of fact or comment, I have in mind that it would unduly restrict defence of fair comment if you were not entitled to look at the material on which it is alleged that the words complained of are commenting. I am not impressed by the argument that you are not entitled to look at the subject matter of the comment because the reader of the allegedly defamatory statement may not be aware of its contents. The ability of the defendant to comment should not depend on whether or not the reader is aware of the material which is the subject of the comment. The defence of fair comment is based on the principle that you should be entitled to comment on a matter of public interest, and the fact that publication is limited does not affect the public interest. If I can now go to Duncan and Neil, which is in volume 2 of the Authorities Bundle at tab 44. And it's at 1320. edition,
Sorry, 240.
it's 1320 of Duncan and Neil. As it happens, this edition was published in 2009. Editors include Sir Brian Neal. 1320, the learned editors state, as discussed above, the extent to which supporting
I'm
facts...
terribly sorry, I'm a little behind. I've got the tab, which
1320.
Page 138, paragraph 1320. You've got there chapter 13 on fair comment.
yeah.
And at the top of page 138, one sees what the learned editors say in relation to this principle. As discussed above, the extent to which supporting facts are stated or referred to in the words complained of may be highly material to the question whether defamatory imputation is to be read as a comment or as a bare allegation of fact. It's been said that the reason why the facts on which the comment is based must be stated or indicated in the words complained of is that the reader ought to be in a position to judge for himself whether the comment is well-founded. There's a footnote there to Lord Nichols. But this is difficult to reconcile with the balance of authority and it is submitted incompatible with the essential nature of the defence. Interestingly there, the editors appear to treat the requirement to refer to facts, state or refer to facts in the word complained of, as being relevant to the question of whether the words are fact or comment. So the first issue, that if you refer to the facts, the allegation is much more likely to be treated as a comment. They don't seem to treat it as a requirement in relation to the second question about whether there is a sufficient factual basis for the comment. And that's reflected in their statement of the principles at 1307 on page 133. Six principles set out there. The comment must be on a matter of public interest. The comment, though it can consist or include inferences of fact, must be recognisable as comment as distinct from an imputation of fact. To this end, emphasised to this end, it's generally necessary that the words complained of should explicitly or implicitly indicate, at least in general terms, a factual basis for the comment. The comment must be based on facts which are true or protected by privilege. The comment must be one which an honest person could have made on the proved facts. I'm sorry, Melissa.
Yes.
Do you have... It's 13, I'm grateful. And then finally, even though the comment satisfies these objective criteria, the defence can be defeated if the claimant proves that the defendant was actuated by malice. I've taken your lordships to Lowe and Associated Newspapers, where Mrs. Justice Eadie respectfully takes issue with...
Sorry, the statement 3 there, I mean, that uses the language of Lord Nichols in Cheng and Paul rather than section 6.
Yes, but it uses it to this end. It's directed to whether the words are fact or comment, which is the first question.
I appreciate that.
And that one can see that in 1320 as well, where it is said, the reason why the facts on which the comment is based must be stated or indicated in the words complained of is, the extent to which supporting facts are stated or referred to in the words complained of may be highly material to the question of whether the defamatory imputation is to be read as a comment or as a bare allegation of fact. So on both occasions, it's related to the first issue. It's not related to the second issue, namely the supporting facts for the comment. It's all kept within the four corners of the publication complained of.
So they're endorsing in effect, they're endorsing the first sentence of Proposition 3, but not the second.
Yes, but they're endorsing it in a different context.
For a different, yes, in different context, but they are endorsing it.
Yes, but only. Well, I mean, they're not. It's not a requirement. The requirement is clear. The requirement is that the author must take sufficient steps so that his words are recognisable as comment. That is the only requirement in this regard. And this is an example of a situation where something may not be regarded as comment.
But sorry.
For example, Jones is a disgrace to human nature.
What?
Jones is a disgrace to human nature. It may not be regarded as a comment because there's no explicit or implicit indication of the factual basis for the comment. In which case, the defence would fail at the first stage. As I've tried to emphasise throughout my submissions, my defence has failed at the second stage. It's not failed on the basis that it's not comment. And when the authors of Duncan Neal refer to this end, it is to the end of the author ensuring that what he has said is recognisable as comment, which is also the issue that was before the court in Telnikov and Matusevic. It's not the issue before the court now. The words are comment.
Have you not also failed because Lord Justice Pill held that the words did not sufficiently, the comment did not sufficiently identify the conduct to which it related, at least insofar as the 2005 allegation is concerned?
And also in relation to the Bibis breach in 2007. He
Yes.
said it didn't identify it.
Yeah.
Yeah. But if one looks at these principles in Duncan Neal, there isn't a principle relating to reference to the facts for the purposes of the second issue, which is whether the comment has a sufficient factual basis. If one goes through these principles, there's nothing there relating to the connection between the supporting facts and the comment.
Not even, I mean, do they touch on section 6?
Well, they do later on, but these are described as the main principles.
In Kemsley, as I understand it, in Kemsley, nobody contended that it wasn't comment. But nonetheless, there are passages in Lord Porter where he talks about the importance of finding sufficient substratum of fact on which to base the comment, to which the comment had to relate. He says that at page 357, as I read it. So he doesn't say you need the facts there in order to show its comment. He says, given that there are comments, you must show enough to justify the comment. You must show enough, you must point to or indicate. And he said there, well, everybody knew what they were talking about. And It was all right, it was public knowledge, and therefore that was okay.
There was a sufficient reference by subject matter.
Yes.
Yes.
But it's not because, not in Kemsley, it doesn't seem to have been argued that the reason for having the facts was in order to show that this was comment.
Yes. I mean, but
It's the other way around, at least in Lord Porter.
but there's nothing in Kemsley which suggests that the reader has to be in a position to judge whether the comments are well-founded.
No, I didn't say there was, but I mean, all I'm saying is that to this end principle, it doesn't seem to be, this justification in paragraph 13.07 doesn't seem to reflect what's said by Lord Porter, for example.
Well, I think at some point Lord Porter does refer to the bare statement that Jones is a disgrace to human nature, and says that that would be treated as a statement of fact because there wasn't any reference to the facts supporting the comment. So I think he talks about it by way of example as an example of the fact-comment
But
distinction.
it's not a very good example, is it? I mean, if Jones had been all over the newspaper headlines and the news bulletins for days, I mean, there might be a question of just why he was a disgrace of human nature, but it's pretty obvious it'd be a comment.
Yes. And Mr. Justice Eadie talks about that in Lowe, if you're dealing with notorious facts. But this is where it gets all extremely complicated, because it's not clear what facts can be relied on, and specifically the extent to which they need to be referred to in the words complained of in order to be relied on. What has bedeviled this defence is really the connection between the comment and the facts. But on one view, it seems that the requirement to explicitly or implicitly indicate goes to whether the words are fact or comment. On another view, it goes to whether there's a sufficient factual basis for the comment. It's clear that the first one is just a question of construction of the article, and the second one starts looking into whether things are true or false or not. One goes beyond the article. As soon as one gets into section 6, however, it is clear that it's impossible for a reader to judge how well-founded a comment is, because a mere reference to a fact does not give the reader any means to make that judgment. So the Lord Nichols' proposition, in my submission, is inconsistent with section 6.
Just looking back at footnote 2 to 1320, the first bit you referred us to, it suggests that Lord Nichols had said the same as he said in Cheng and Ball in the earlier case of Reynolds and Times newspapers, in which he gave the leading speech in the House of Lords. But in fact, I just turned it out, he didn't go as far in Reynolds, I think, as he did in Cheng. The footnote suggests he said the identical words in both, but he didn't.
No, it might be helpful to actually go to Reynolds. Just to see exactly what Lord Nichols did say on that occasion, because, I mean, clearly any statement of principle from Lord Nichols is worthy of the highest respect.
Well, it's more than that, because I think everyone else in the House of Lords agreed with him.
Yes,
I think.
Well, I mean, again, it was even more a passing reference in Reynolds, because Reynolds was about qualified privilege. In Cheng it was about fair comment, but only in relation to malice, and these were just passing observations.
Where's Reynolds?
Tab 31, and if I can ask for the assistance of Lord Walker for the... I don't have the reference exactly.
Page 201 between E and F.
I'm most grateful. Perhaps if we can just start at D. The crux of this appeal, therefore, lies in identifying the restrictions which are fairly and reasonably necessary for the protection of reputation. And this was in the context of permitting false defamatory statements of fact to be protected. So at E, Lord Nichols says, in the case of statements of opinion on matters of public interest, that is the limit of what is necessary for protection of reputation. Readers and viewers and listeners can make up their own minds on whether they agree or disagree with defamatory statements which are recognisable as comment and which expressly or implicitly indicate in general terms the facts on which they are based. Yes, and I'm grateful to Mr. Caldecott. 193, since we're on Reynolds. This is Lord Nichols' analysis of honest comment. And at F, he says, it's important to keep in mind this defence is concerned with the protection of comment, not imputations of fact. If the imputation is one of fact, a ground of defence must be sought elsewhere. Further, to be within this defence, a comment must be recognisable as comment, as distinct from an imputation of fact. The comment must explicitly or implicitly indicate, at least in general terms, what are the facts on which the comment is being made. See discussion in Duncan Neal on defamation. Now, I'm not sure what's in the second edition, but what Lord Nichols seems to be regarding the explicitly or implicitly indicate requirement as being a secondary requirement on top of whether the words are recognisable as comment, whereas Duncan Neal, certainly in the third edition, treats it within the obligation to ensure that your words are recognisable as comment.
Actually, this passage here then does support the footnote, doesn't it? I mean, isn't this much the same language?
Yes.
I mean,
Not the last bit.
what?
The reader of the hearer should be. Oh, fact, yeah, isn't it?
Sorry, well, I'm just, where do we find that? If we look at paragraph 19 of Cheng, or whatever it's called, I think, it's pretty much the same, isn't it? The comment must expressly or implicitly indicate, at least in general terms, what are the facts on which the comment is being made. It's difficult to think that when he wrote his judgment in Cheng, he didn't have Reynolds in mind.
It's clearly being treated as an additional requirement to the requirement to ensure that the words are recognisable as comment.
It must be recognisable comment, and there must be enough fact to show that they are recognisable as comment, and the fact must be enough to justify the comment which is made.
Yes.
In that broad term.
But the indication of the facts is only relevant to the first question: is it recognisable as comment? If you've got supporting facts which are capable of supporting the comment, they don't have to be indicated in the words complained of in my submission. But in any event, in this case, the words were sufficiently indicated in the words complained of, or at least arguably so, and it's a jury question. But what is clear is that a mere reference to a fact does not give the reader the means to work out whether the comment is well-founded or not. And any requirement on the part of a commentator to do so, on pain of which he would lose his defence, which would otherwise be viable, would be contrary to the jurisprudence of the Strasbourg Court, not only in terms of the importance that is accorded to value judgments, but also the consistent principle in Article 10 cases that the form in which ideas or information are expressed is generally for the author to decide without interference from the domestic courts. And I've referred to Jersil case, which is one example. There's numerous cases expressing this principle in various ways with which the court will be familiar. And clearly any requirement to set out the facts sufficiently clearly to enable a reader to judge whether a comment is well-founded would be a considerable fetter on an author's style for writing words which one must assume a comment and which have a sufficient factual basis. It would give rise to legalistic, turgid writing. Commentators would have to engage in a detailed exposition of the facts before they could get to the comment. It's not just a question of whether you've referred to your facts. There are other issues, such as if the reader's got to be in a position to judge whether the comment is well-founded, then all the facts that might bear on the validity of the comment would have to be set out, because a reader can just as easily misjudge the validity of a comment by giving a selective choice of true facts as opposed to a false fact. So I repeat the submission I made before based on the American cases, that in general the validity of an opinion ought to be tested in the marketplace by encouraging further debate, not by defamation litigation. I'm not submitting that there should be an absolute bar on bringing actions in relation to opinion. I'm submitting that, judged objectively, there must be a sufficient factual basis for the comment, but that is the only requirement once the words are comment. This is particularly important in the age of the internet. If fair comment is to be the bulwark for freedom of expression, it's got to be user-friendly, it's got to work, it's got to be sympathetic to the mode of publication. And the internet is a classic forum for the expression of opinion by ordinary members of the public through a variety of sites that allow direct input from users. And it's in the nature of these sorts of publications that they will contain statements of opinion, but will not necessarily set out all or any of the facts on which they are based.
That's the respect in which you differ most markedly from established authority. Not the add-on by Lord Nichols, so that the reader can decide for himself whether the comment is justified or not, is a gloss on the basic proposition that the publication, if it's going to be subject to the defence of fair comment must not only be seen to be comment, but must identify what it is that the comment is based upon.
Yes.
And that's your real complaint, isn't it?
Yeah, but my primary
Okay.
submission, I'm sorry if I didn't make it clear, my primary submission is that on the facts of this case, my clients have sufficiently identified the factual basis for the comment.
And the Court of Appeal were wrong.
Yes, plainly wrong in my
Yes,
respectful
yes.
submission. That is my primary submission.
Yes.
And my ally to that is that whatever the general requirement is, Section 6 permits facts to be referred to. Now, if explicitly or implicitly indicate is a higher hurdle than referred to, then it can't be right, because Parliament has allowed that level of reference to a defendant for his factual pool. And that level of reference may not enable the reader to judge the comment. So it's only when all that has gone, and we've lost on all that, I make my wider submission that there shouldn't be any requirement of reference whatsoever. And incidentally, that is what Lord Leicester is proposing in his bill. Now,
Should we adjourn now until 2 o'clock?